Welcome to the Foul Play YouTube channel.
Greetings and salutations, and good afternoon, good morning, good evening to everyone. Welcome to open mic number 90. 90 of these things. How have we done it? Where's the time gone? Anyway, today we're continuing on with these dozens and dozens of pages of filings from Lita Walker and these defendants that on this Colborn v. Netflix case. And we're going to be picking up, first one we've got is about a 48-page document. We're going to get through that. And we have several more that some of them are like 7-8 pages, and then some of them are very short, just a few pages. So, but we'll continue on. We'll get as far as we can. But first, hope everyone's doing okay today. And let's say hello to let's be nice and say hello to everyone here in Discord. How are you doing today, Alice?
I'm doing good, thanks, Jack. Hi to everyone in chat. Hi everyone on panel. Looking forward to getting back into these documents.
Thanks, Alice. And Cherie, how are you today?
I'm doing well. Hi, everybody, and welcome to Open Mic.
And Jinxie, how are you today?
Hello, everyone. Sorry we're late. Was busy talking about porn.
And Sunshine Christina, how are you today?
I am well. I'm excited to be here and to see what else, what little nuggets we have. Hello to everyone in chat. Hello to every panel. Jinx, I have missed our healthy, feisty debates. I was like, wow, I've missed you. So I do enjoy that.
I'm glad you're back, by the way. I've missed you too. Good to have these healthy debates.
Yeah. It gets our brain spanking.
It's the way to get to the truth. That's what we got to have. All right. Well, thanks, Christina. Glad you're here. And let's say hello to everyone in live chat that's arrived so far. We've got JD. I just see him. Roxana, thanks for coming. And the lovely, lovely Dark Side. Pete Moss, Catalyst Studios UK. Hey, that must be Andy the Bee. Hey, Andy. Little Barb.
Ronald Decas.
Little Barb. Yep, Ronald. There's Behind the Magic.
West Virginia. Galatacky. Keep an eye on that one.
Yep, absolutely. Yep. There's Angie. There's Angie and Joffrey.
Colette.
Ruth Weber.
Clyde.
Ruth Weber, I don't think I've seen your name. Thanks for dropping by. Hope you enjoy the discussion and the documentation. West Virginia, hey, thanks for coming. Yep, and you said Ron.
Yeah, we've got Cher. Hello, Cher.
Hey, Cher, thanks for coming. Yeah, you know what these Oh, I'm sorry.
Behind the Magic. Sorry, Jack. We have Behind the Magic. She says, hello, everyone. I finally made it to the start of a live. Woohoo! Nice to have you with us, Behind the Magic.
Jazz Naz. Hey, Jazzy.
Katie did it. We've got Katie did it. Hey, Katie. Nice to see you.
Yeah, these documents, you can look at this several different ways. We get the fact that not every single document has like interesting and got little, maybe a little more exciting nuggets to read through, like some of the text messages and stuff. But again, for me, this is my stamp. This is my viewpoint. Now, I know not everyone, I'm not asking anyone to agree, but to really understand what the judge is going to be looking at. This is not, we're not even close to jury and all that shit. This is what the judge is going to be going through and reading. And for, to kind of understand whatever rulings that he comes up with whenever that happens. I can't, I think I maybe mentioned to Sharia, I'm wondering when we're going to have the next status update, another hearing to just, kind of find out where everyone's at. He's, I'm sure he's busy, like all federal judges. I'm sure he's loaded with cases, but it's been a while. So I'm wondering if that's not going to happen sooner rather than later at this point. I think that it really should, but what do I know? Given the fact of how many documents got submitted, remember, we started this whole new document process at document 267. And so far they run through document 296. So that's how many there are. Now there are some that we don't have. We don't have access to. They're not on Pacer, so we can't get them. But nonetheless, we have most of those. Anyway. So with that said, hey, there's Colette. I just saw her.
And Jazz Naz. Hi, Jazz Naz.
Yeah, I saw Jazzy. Let me get these pulled up here. So this first one that we're starting on is Exhibit 48, but it's actually document 51. So we're close to the end of the exhibits, attachments, whatever, for document 279. Remember, it has 52 attachments. So we're close to the end. And there's been some interesting things revealed, and I imagine these last two are going to have a few more interesting things that it's going to trigger some discussions. Let's go ahead and get started. We're a few minutes a little bit later than what I wanted to start, but hey, here we are. This first one is like I said earlier, it actually says 49 pages, but I imagine it's probably going to work out to 47, 48 generally. There's signatures at the end. So let's go ahead and get rolling with this. I'll start off the reading. I'm not saying that I won't have one of my helpers here, maybe Alice or Cherie or someone. Susan's busy. Jess Rhonda, I'm guessing she's busy too. I haven't seen her yet. So, or even, we'll see. We'll try to pass the hat around so you're not listening to the same voice. I like to do the interactive. Everyone seems to enjoy that better. So anyway, let's get started here with this first one. And this is a plaintiff's responses to Defendant Chrome Media's first set of interrogatories. So these are going to be Colborn's responses to Chrome Media's interrogatories, which probably happened sometime. I don't know the date, but I'm guessing sometime last year. I don't remember any interrogatories happening this year. Plaintiff Andrew L. Colborn, by and through his attorneys, law firm of Conway, Zach, and Jerry, SC, response to Defendant Chrome Media, LLC's first set of interrogatories as follows. General objections. To the extent that any of the interrogatories call for information which is protected by the attorney-client privilege, work product, doctrine, or otherwise immune from discovery, plaintiff hereby objects to furnishing any such information, and such information is not being provided. To the extent that any interrogatories go beyond the scope of Federal R. Civ P26, plaintiff objects and will comply only to the extent of the obligations set forth there. Plaintiff also objects to the wording of defendant's request on a basis that Wisconsin law requires that defamatory broadcasts be considered in their entirety, not just a collection of allegedly separate statement. The entire man broadcast must be considered with respect to their falsity and defendant's knowledge or of falsity and or reckless disregard of the truth with respect to the broadcast. Plaintiff objects to the interrogatories to the extent they suggest or imply otherwise. Yeah. Okay, well, that just goes to a cherry picking session to me, but anyway. Discovery and investigation are continuing in this matter, and plaintiff reserves the right to amend and or supplement these responses accordingly. In addition, plaintiff's counsel has only just been able to produced raw material to viewable format, and have not had an opportunity to view it yet. And again, plaintiff reserves the right to supplement his responses accordingly. Subject to the foregoing objections and specific objections listed already below, plaintiff respectfully submits without in any way conceding relevancy or admissibility the following responses to the interrogatory. Interrogatory number 1. Identify with specificity all spliced and omitted portions of plaintiff's trial testimony as set forth in Exhibit A and B that you contend distort the facts and nature of the 1994 or 1995 telephone call, and led viewers to falsely conclude that plaintiff bears responsibility for 7 or 8 of Avery's 18 years of wrongful imprisonment, providing him, Colborn, with a motive to frame Avery for Halbach's murder, as alleged in the paragraph 27 of the second amended complaint. Response number 1. Subject to the plaintiff's general objections, plaintiff refers to the summaries attached in a chart form hereto. Discovery and investigations are ongoing, and plaintiff reserves the right to supplement his responses accordingly. I'm pretty sure we don't have that chart unless it's listed below. I don't remember seeing it. That don't mean anything. Interrogatory number 2. For each quote-unquote spliced and omitted portion identified in your response to the interrogatory number 1, state how the spliced or omitted portion, quote, distorted the facts and nature of the 1994 or 1995 call, and led viewers to falsely conclude that plaintiff bears responsibility for 7 or 8 of Avery's 18 years of wrongful imprisonment, providing him, Colborn, with a motive to frame Avery for Halbach's murder, end quote. That's alleged in paragraph 27 to the second amended complaint. And this is basically the same response. Subject to plaintiff's general objections, plaintiff refers to the summaries attached in the chart form hereto. Discovery and investigation are ongoing, and plaintiff reserves the right to change his answers accordingly. Interrogatory number 3. Describe in detail all the facts that you contend support your allegation in paragraph 33 of the second amended complaint that, quote, defendants knew of falsity, end quote, of Stephen Avery's criminal attorney's suggestion that plaintiff was looking directly at Halbach's vehicle when he called dispatch. Response number 3. Subject to plaintiff's general objections, plaintiff responds as follows. Plaintiff's testimony at the civil trial regarding the call that he made to dispatch was reasonable and credible, and he specifically denied that he was looking at Halbach's vehicle during the testimony. In addition, upon information and belief that the defendant had reviewed the Avery trial court's decision and order dated January 30, 2007, which explained that any theory regarding any alleged involvement in plaintiff in planting Avery's blood in Halbach's vehicle was extremely weak and rested on an unexplained contradiction. As pointed out by the state at oral argument, how could Lincoln Colborn have known that Teresa Halbach was dead at the time they are alleged to have planted the defendant's blood in her vehicle? Under the defendant's theory, either Link, Colborn, or both would have had formulated a plan involving their own commission of serious felonies and executed that plan with a very short period of time, motivated apparently only by their embarrassment for not alleging to having acted more responsibly on the information that could have led to Mr. Avery's exoneration back in 1995 or 1996. Decision and order at page 11. It was only due to the extremely low bar afforded criminal defendants by law to attempt to offer theories and to attempt to exculpate themselves that this theory was even allowed to be presented by the judge. Under any common sense or reasonable standard, the assertion that plaintiffs had found Halbach's vehicle prior to the time that she was known to have been deceased was obviously false. Defendants are educated persons. Both have advanced degrees. In addition, Ms. Riccardi has a law degree and practiced law for some time after graduation. Accordingly, it is reasonable to infer that both Riccardi and Demos knew that there was no reasonable basis to believe that plaintiff planted blood in Avery's car, that any theories to the contrary border on the fantastic and are patently ludicrous, and therefore they knew it was false. Well, I'm going to just interpose my own little objection here, I guess, because There could have been other ways that Lincoln Colborn may have known that Teresa was deceased. Not that necessarily that they killed her, that there could have been other conversations with someone else. I'm not saying that's what happened at all. That's just my answer to that, because clearly they work with a lot of other people in their department and other departments that they're connected to. So that response.
Jack. Nobody, not even the lawyers or the parents specifically said Colborn was to blame for Teresa's murder.
That's right.
They implied.
That's right.
No, they implied that it was the department. So it could have been any one of the police of the MTSO that shouldn't have been anywhere near the property in the first place because it was a conflict of interest. But they didn't look at it that way. So it's only obvious that people are going to come to the conclusion that if they're not, why are they on the property when there's a conflict of interest like that? And the only reason why they could be on the property when they're not supposed to be is if they're up to something nefarious.
Yeah, I mean, the only thing I can say about that is that, as we talked about yesterday, Willis allowed the defense to explore more in depth, not from a Denny standpoint, but more in depth with Lincoln Colborn being MTSO officers at trial. So I get why he's trying, why they're, this replies this way, this response. At the same time, they're taking, they're taking this stance that the filmmakers accused them of killing Teresa, and that came from Kratz. That didn't come from the filmmakers. Kratz is the one that suggested that shit to the jury.
Yeah, yeah, but Colborn thinks it's all directed at him. And I mean, as Nosey says, lol, common sense. Aye, they've got a cheek to bring common sense up in a response to anything in this case, because not one of them, including Colborn, had any common sense when it came to this whole in a bloody case.
Yeah, I can't disagree with that. Okay, well, I just wanted to kind of throw that in there. Anyway, let's. I don't see any questions. Looks like Iced Coffee's joined us, and
Yep, case 10.
Yep, and Nosy, my internet wife, has joined us. What else we got? That's all I see right now. All right, let's move on. Interrogatory number 4. Describe in detail all the facts that you contend support your allegation in paragraph 40 of the second amended complaint that, quote, defendants manipulated facts to convince viewers that MTSO officers possibly, including plaintiff, secreted Avery's blood from a vial still kept in evidence from his wrongful conviction case and planted it in Halbach's vehicle or Halbach's car, end quote. Response number 4. Subject to plaintiff's general objections, plaintiff responds as follows. The facts that supported the allegation that defendants manipulated the facts in question are set forth in the remainder of paragraph 40 of the second amended complaint. Upon information and belief, defendants had reviewed the Avery trial court's decision order dated January 30, 2007, in which the court noted that the fact that the state intended to present evidence that the hole in the blood vial stopper had been created by a phlebotomist who withdrew Avery's blood on January 2nd, 1996. Interrogatory number 5. Describe in detail all the facts that you contend support your allegation in paragraph 64 of the second amended complaint that challenge statements, quote, tended to harm you and actually irreparably harmed and damaged your reputation, lowering you in the estimation of the community and subjecting you to hostility, hatred, and ridicule, and deterring third persons from associating or dealing with you, end quote. Response number 5. Subject to plaintiff's general objections, plaintiff responds as follows. Plaintiff's counsel will be producing copies of numerous recorded voicemails that plaintiff received from threatening and verbally abusive male viewers across the world, and plaintiff designates those documents in response to this interrogatory. Plaintiff's counsel will also be producing copies of email messages and online posts to the same effect. In addition, plaintiff will testify regarding the counsel's telephone calls that he received at his personal residence and at work that were not recorded. Due to the intense verbal abuse that plaintiff suffered from the public at large following MAM broadcast, plaintiff eventually resigned from the sheriff's department earlier than intended. In addition, the effect of the abuse on plaintiff has contributed to the demise of plaintiff's marriage of multiple decades. Plaintiff also incorporates in this response his response to the interrogatory number 8 below. Damages are ongoing. Plaintiff preserves the right to supplement this response as discovery and investigation continue. Yeah, it wasn't MAM that caused the demise of your marriage just because you couldn't keep it in your pants. That's my reply to that.
That's, you took the words right out of my mouth there. I was going to say that myself. It was because you couldn't keep your ding-a-ling in your pants.
Yep. You gotta keep the trouser trout zipped up there, pal. It's just the way it is. And that's what causes the demise of your marriage, not making a murderer. Okay. Interrogatory number 6. For each of the challenge statements, describe in detail all the facts you contend support your allegation that the producer defendants published that challenge statements with knowledge of their falsity or reckless disregard of their truth or falsity. Response number 6, subject to plaintiff's general objection, plaintiff refers to the summaries attached to the chart, blah, blah, blah. Interrogatory number 7, for each of the material facts that you allege you was omitted from making a murderer, state that omitted fact and describe in detail why you believe the producer defendants had knowledge that omission of the fact would cause making a murderer to be false, or that producer defendants omitted the fact with reckless disregard of the series truth or falsity. Response number 7. Subject to plaintiff's general objections, plaintiff refers to the summaries attached in chart form here too, and the allegations of the specific paragraphs of the second amended complaint that are described as challenged statements. As factual basis for many of the allegations is set forth there, including detailed descriptions of the specific alterations to and omissions of the trial testimony by the defendants. Defendants knew that alterations changed the impact of the testimony, and it is evident that they made them for that reason, in order to continue to tell their story. This is further corroborated by the document produced by Netflix, which demonstrate the involvement of Netflix personnel in attempting to make the story more dramatic and to emphasize plaintiff as an alleged villain of the story. See plaintiff's response to the first set of interrogatories of Netflix Inc. Discovery and investigation are ongoing, and plaintiff preserves the right to change his answers. Well, just a brief response to that. Netflix is in the business of selling their video, whatever, their stuff, their product, whatever that takes. And to me, nothing, absolutely nothing. I've read the trial testimonies numerous times. There's nothing in making a murder that alters my view of Colborn, or actually reading the information outside of the series is far worse. That's the truth. That's my opinion.
So
Completely agree with you, Jack.
yeah. So let's see. What didn't making a murderer tell us that we know? We know that he's unfaithful. We know that prior to the license plate call, he was asked if he had found out who those plates come back to yet.
Yeah, actually, I just listened to that call a few minutes ago.
And also, we found out that unlike his testimony at trial, that his integrity had never been questioned before. He had actually been accused of stealing from an inmate when he was a jail officer, and was written up for not following protocol when it comes to securing and then releasing inmate property.
Yeah. And there's just a whole array of things that make murder factual things that they left out. There's just no way that they could put it all in there. No way. And
No. Kelly McCallan in chat says, do you remember who told them to go and search again? I think she asked earlier, where do I find it again, about who told them. Why did Lincoln Colborn go to Stephen's trailer for the 7th or 8th or umpteenth time? And who was it that sent them? Was it Pagel?
That's a great question.
I don't remember, but there was another search warrant that they wanted something. I can't remember if it was a computer or they sent them in there at
the magazines.
No, not that search. No.
See, in my opinion, Pagel should not have been the one in charge. There were 2 lead investigators, supposedly, who were basically leading the rest of the officers. At least that's how I understood it, which would have been Wiegert and Fassbender.
Yeah, well, I mean, they report to they report to Pagel, but I don't remember who actually told them to go after whatever it was. It wasn't porn. That was a secondary thing, because I remember reading a report somewhere, don't ask me where, that they wanted to go, Colborn wanted to search something else again, and that's why he went to the bedroom.
And then when they didn't get enough from Brendan, the person who sent them back to Brendan was Kratz.
Yeah.
Because Kratz is actually the face of the case, right? Like, he's the one who's supposed to be like, they take their information to the DA and say, here's what we have. And the DA is like, okay, that's enough. Or, okay, we need more.
We need more.
Yeah. Get more. So technically, in a way, Kratz is kind of the lead guy.
I was just typing it in the chat. I think that they got an additional search warrant for something.
They did. They got. I can't remember what it was for. I want to say some serial number off of something, or I just don't remember the piece. But I do know that
it might have been for the computer. It might have been the serial number off of the computer. But the computer, Stephen's computer, unlike Bobby's, was kept in his living room. So they really had no business being in that bedroom.
That's right. That's right. And it had already been searched before. It had been searched 2 days prior.
Twice or 3 times. And then I just want to say I agree with Jinxie. When DCI investigators came onto the scene, because Deb Strauss, even though I don't even think she wrote 1 report, she may have.
She did. She did do it. She wrote a number of reports, but a number of them we can't get, or we were denied.
She was present when she was present at the blinker light interview of Brendan. She was present from the 5th on, every day, and she was in the circle when everything was found. It wouldn't surprise me to learn that she was in the trailer when the key was found. That, because
who is she?
Deb Strauss.
Oh, Strauss. Okay.
Yeah. Yep. She was present for all of it. And she had more experience with Manitowoc's nefariousness and Stephen Avery than anyone else on the scene. And she was a senior officer by that time. She should have been in control of all of it. And she likely was. They just didn't say that she was.
Ice Coffee brought up a good point. We've discussed this before. Ice Coffee says, do they have to have a specific reason to warrant each search, and then so they can't just re-enter as they please? And that point was brought up by, many people have brought it up. As I've read many cases, typically judges will allow 1 search for, it may last a couple of days at most, maybe 72 hours. But in this instance, they were given basically carte blanche. And that is virtually unheard of what they did. They entered the garage, the house multiple times. I'm talking about Stephen. I think they were in the Dassey house a couple of times, and then they were back in April again to the Dassey house to get the computer. They were back in March at the Avery's to get into the garage so they could, find the bullet that they missed on the first million searches back in November. So in that capacity alone, I think that Meeting and Strain actually argued this. How many times are police allowed to go in and find things when they didn't find something before? It's ridiculous how many times in this case. Absolutely ridiculous.
It's also different that you're not allowed to be on the property, because in all other search warrants I've heard, you're allowed to stand there and watch them take what they do. You're allowed to call your lawyer and have your lawyer stand there with
That's
you.
right.
So why was it in this case? It was not just, I mean, they did several warrants over that week because they had to keep doing them because you couldn't have it for more than 72 hours or 48 hours or whatever it was.
That's right.
So that's also suspicious. Why weren't they allowed to be on their own property to at least watch it? They should have been able to park their own car on the property and watch the cops overnight.
That's right. That's right. That's I don't know how they, and what is it in Wisconsin law that allows them to seize the property and run the occupants completely off of it, but they did. They ran them off. So that's another aspect of what they did is really questionable to me. Why was Ryan and Scott allowed in? Yeah, it's a damn good question, Darkside. Don't know. Can't answer that one either. Scott or Ryan Kilgus. You know what you're talking about? Ryan Kilgus.
Kilder.
Anyway, let's move on. Interrogatory number 8.
Yeah, we've had a couple more people join us in chat, Jack. We've got Ice Coffee who's joined us. We've got Ruth Robinson who's joined us. So that's us. We've got 2 Ruths and 2 Rhondas. Ultra Collector Customs has joined us as well. And Ultra Collector says they discussed with each other that they thought Stephen was innocent, but that Zipperer and Scott seemed guilty. Pagel then changed the plans and sends them back in there.
Well, I mean, we see it.
He was the one who was the boss who had a change of plans. When he says the boss had a change of plans, for Wiegert to say that, Wiegert's boss was definitely Pagel.
Pagel, yeah, absolutely. But these uppers were communicating. Don't forget about the call on November 5th that AAG called in all frustrated and ramped up. He had just talked to Skorlinski, the Special Agent Skorlinski from the DCI, and this AAG needed Rohr's phone number now. They've got to talk to him now on the evening of November 5th. So what the hell did Skorlinski say to him?
I didn't know about the
Skorlinski. They tell this guy, Stephen Avery is suing this whole county and 2 of its, one of its ex-employees, ex-sheriff, and Vogel. He probably I'm wondering if that's the reason Rohr recused himself, was because he was told to by the AG or the assistant AG.
The AG that we're discussing, his name escapes me at the moment. I want to say it was Robert something. The AG was part of the, quote, Avery task force, unquote.
You're talking about the one that called in?
Yeah.
That's Freiberg. Freiberg.
Yeah, Freiberg, yes. He, if I remember correctly, I found some online stuff that showed that he was part of the, quote, Avery task force, quote, unquote. And I think you're exactly right, Jinxie. I think he said the optics aren't going to look good if Manitowoc heads this. Did he call in at first because he knew that Stephen was being set up? Who knows?
Yeah, but the thing is, he says on the phone he just talked to Special Agent Skorlinski, and he needed Rohr's number.
That's
So
right.
what the hell does Skorlinski say to him that got him all ramped up like that? And why would Skorlinski be talking to this? Why would he be talking to him anyway? I don't know.
Yeah, it's really weird.
Absolutely.
How do you spell that guy's name?
Freyberg. It's Freyberg, I think. Jinx.
Yeah, I think Freybe or Burg. Yeah,
I think it's BE. I think
it's Robert Freiberg, isn't it?
I can't remember his first name.
Is it Gary Freyberg?
I think you're right.
Gary. I think that's it.
Gloria and Barbie has joined us in chat. Hi, Gloria. Hi, Barbie. Thanks for joining us. Barbie says, what really needs to be done is an investigation done on Manitowoc and Calumet counties. Yeah, I completely agree with that. 1000%.
And the DCI and the DCI. Sorry, but
of the Wisconsin criminal justice system, from the AG's office on down.
Yeah, but it needs to be somebody out with both of them, so that it is a completely different. No, the Wisconsin DOJ investigating these two counties, because that's happened before, and they lied and they said that nothing was wrong or nothing was done wrong in Stephen's 85 case. So it really needs to be taken out of that state completely and bring somebody completely fresh in. It needs to be
it needs to be the federal. It needs to be the federal that investigates them.
But it has to be. I think what Alice is saying is, even if they bring in federal agents, they need to be federal agents far removed from Wisconsin.
Oh, I don't disagree.
Yeah.
I don't disagree with that at all.
Because the FBI agents that participated in this case either went to school with, had worked in Wisconsin, or had prior professional contact with many of the assistant attorney generals and the DAs in this case.
Well, these guys get stationed. There's federal FBI offices located all throughout the United States. So these agents that work for the Fed, they're just regular people like everyone else. They get into a community and they become friends with other law enforcement officials, state people. So relationships form. I get it, but I disagree. It needs to be investigated by someone far removed from that area, with no bias.
Especially if they go to university with them before they even become officers.
Yeah, absolutely.
Yeah, that's why it needs to come from a completely different state.
Go out west, go Washington or Oregon or somewhere out there and bring them in.
Yeah, even as far away as that, because if I remember right, that used to happen here, and it used to be that the police station, if there was complaints about a police station, then it was like a police board sort of thing that investigated them. Well, that's the police investigating the police, you know what I mean? And it can't work that way. So it then becomes an independent review, which is people completely apart from the police, period. Like, it could be an ex-judge, an ex-civil servant, something like that. And they have their own people to follow up investigations, interview people, get documentation, things like that. And they look at the whole thing, the investigation, the police officers themselves, the departments that the police and that were working for. Why was this not done this way? Why was this not done that way? And then they put it all together and they give a report. And that's how I think it needs to be done when it comes to Calumet and Wisconsin.
I wouldn't if the governor or the legislation in any state actually chose to put up a citizens review board that had actual subpoena power and arrest power, I would be okay with that. But they have to be unconnected to anyone in law enforcement. Unconnected. It's just like, if you have a spouse or family member that works, let's just say, for the lottery commission in your state, you're basically barred from participating in, because you've got a connection to that person. So this would have to be the same. Getting off track here.
Yeah, years ago, I'm just going to share this and we can get back to it. Years ago, there was a brief running show, and I think it was called Dallas DA. And after about 20 to 30 years of these unethical elected district attorneys in Dallas, the first Black DA was elected. And what he did is he put together a board of public defenders, ex-retired, what's it called? Texas Marshal or whatever they're called.
Yeah. Rangers, Texas Rangers.
Retired Rangers, a couple of FBI agents. And what they did is, I guess he knew there were several cases that where there were innocent people in prison, and he put together this board. He raised the funds, got this board together, and they went through, and I don't want to misquote, but I want to say they reviewed 50 cases, and over half of them were wrongful convictions, and they were all part of like prosecutorial misconduct. It's a really good, I think the show was on A&E. If you haven't watched it, anyone who's interested in like how to try and, I always thought that would be something good to do. Wisconsin will never go for it because they're corrupt from the top down. But if you have a good DA, it's a good model for trying to write some really tragic cases that have occurred.
Unfortunately, it seems like it's just spotty. There are DAs out there that are trying to do the right thing, to seek the truth for cases and not just get a conviction. But there's so many that it's all conviction based. They don't, or worse yet, are the bane of my existence, plea bargain. God, I don't even like saying it. Hey, there's catnip. But yeah, anyway. Yeah, let's get back to it.
Or their DAs like Bob, what's his name? Hang'em Bob from Oklahoma.
Bloodthirsty Bob Macy.
Yeah, Bob Macy. Or their DAs like Bob Macy, who just enjoy being cruel to the underprivileged.
Absolutely. He was, his legacy, it'll take 500 years for the legacy of that man to kind of die down. He was so bad. Anyway, we've got others that have joined us. Looks like there's some good conversation going in the chat. We appreciate everyone that's come along to listen to these. Let's read these documents. But speaking of that, let's get back to it. And this is interrogatory number 8. Let me get a drink. All right, interrogatory number 8. Describe in detail all items of damage you contend you sustained as a result of producer defendant's acts of omission alleged in the second amended complaint. Response number 8. Subject to his general objections, plaintiff responds as follows. Making a murder damaged, if not destroyed, my reputation, my health, and my personal life. My reputation as a police officer, so important to maintain as a trustworthy and being with integrity as well as honest, and was severely damaged as millions of viewed and believed the falsehood that was making a murderer. In the social media realm, my reputation was totally destroyed as I was and still am portrayed as a poster child for corruption. I began to fear that this annihilation of my reputation would affect the weight of my courtroom testimony on other cases, effectively ruining my career as a police officer. My health was affected, as I did and continue to live with in a state of constant hypervigilance, as making a murderer prompted a multitude of death threats to me and towards my family. Never being able to totally relax, as well as constantly anticipating an attack on me and or a member of my family, has caused me to develop both hypertension and anxiety, which has to be treated with prescription medication. Due to the stress caused by ma'am, I have trouble sleeping, and I find myself often angry and irritable. I no longer feel I can trust anyone totally ever again. My personal life has also been greatly damaged as a result of my inability to go back to the person I was before ma'am has destroyed my 30-year marriage, and the marriage ended in divorce. I have lost family members and friends because of ma'am's false narrative, reckless agenda, and portrayal of me, which is only exasperated by the social media crazies who continually, 7 years after its release, claim that I am a corrupt, evil person and that ma'am is truthful. I am often confronted by total strangers who inform me that they despise me for what I've done regarding Stephen Avery. I'm not allowed to be present at any media event at my current employer, as my presence could be disruptive. Wow. That's a hell of an answer, and we know that much of it's false. I'm not going to say all of it, because there are some crazies out there that acted inappropriately. No one here on this panel, and dare say no one in the live chat or anyone listening that's not spoken, would ever agree that any death threats or any of that shit towards Colborn or his family is right. They need to be prosecuted if they've broken the law. Sorry, you can't do that. Don't agree with any of that shit at all.
And we know from interoffice emails that one person was actually arrested for making death threats. One person. So that tells me that he has greatly exaggerated the death threat. And also he does realize you can't just make allegations. You have to actually corroborate them with evidence. Yeah. Right? I mean, they do know how a court of law is supposed to work.
Well,
they convict Dassey without any corroboration of any evidence. So
exactly.
It was going to be the same for him.
I have to wonder again, did Griesbach really think his brother was going to be able to try to judge this case?
I would hope not. God, I would hope not. I mean, even if I doubt he thought he could actually touch it because of the connection, he would need to recuse himself away from it.
He had to recuse himself from the suit against the county, Kosoric, and and Vogel, because he was originally appointed the judge on that, wasn't he?
Yeah, I think so. I think he had to. Yeah, I think you're right, Jinx. I think he had to recuse himself.
Know that. So he was a state judge when. Oh no! You're saying in Stephen Avery's civil suit, right?
Correct. He was first appointed as the judge in the civil suit, and then they're like, well, no, because look, this is Griesbach's brother. How can he be biased?
Yeah,
Griesbach's part of this case file.
Yeah, he can't be part of
the. We're talking about the 05 case, right? I didn't know that.
Oh, well, it would have been 2004, yeah.
I did not know that his brother was had to recuse himself from that case. Huh. Good.
Yeah, and even though he couldn't actually play a part of this, friends of friends, judges, birds of a feather, who knows if he had thought like he could count on his brother to maybe influence things behind the scenes. I don't know.
Because now, correct me if I'm wrong, but in the Colborn case, he did rule over a couple of motions. He did get the case past the initial filing, right?
His brother? I don't think so.
Yeah.
Okay. No, I don't know. It was another judge that had it first, but it wasn't. I don't think it was his brother. It was I can't remember the judge's name, but it did change to Judge Ludwig at some point for whatever reason. I don't know why. Yeah, I have to go back and look. I don't remember the original judge's name way back, but nonetheless. Anyway, for Colborn, he's changed these, as we all know. This, like I said, I'm sure this is from last year. He's not blaming man for the dissolution of his marriage now. It was because he fooled around on his wife for many, many years, decades. And, of course, that fucking crushed her. I'm sure it did. And damaged his relationship with her children, which, he basically raised. And though I think they've got one child of their own between them. So I'm sure it damaged that relationship. Of course it did. So anyway, that's gone. As a police officer, again, I'm not going to get into all these different symptoms, he's experiencing. I'm sure that some of the idiotic behavior of some people out there, there are other documentaries that have caused problems, and not just documentaries, but other presentations out in social media that have caused idiots to behave badly towards cops and other people involved. There's no justification for that whatsoever. I'm sure they did raise his hackles. I have no doubt. I mean, if that happened to my family, I would be freaking sideways. But with that said, as a cop, he's gonna be hypervigilant anyway. He's gonna probably have ramped up blood pressure anyway, just being a cop. That's just part of it, And as we've also learned, no one has really seen too much of anything of outward symptoms other than his wife's damn, I can't think of the word, not affidavit, but whatever. She said that, he would pace the floor and when during trial and he was, withdrawn and that kind of stuff.
During trial, not after watching the documentary and receiving all these, quote, threatening phone calls, unquote. I would personally, let me just say, first off, I am so proud of how you remain unbiased and you still try and play devil's advocate 6 years in, knowing all you know. Hats off to you because I'm over it. Two, I would love to hear these 86 calls because it wouldn't surprise me to learn about 60 of them are just garbage. The same guy calling over and over and over again, probably the one they arrested. And the other 26 are just, y'all are corrupt assholes and you're going to burn in hell for what you did.
Yeah, that was part of, what he said in one of the newer, in his deposition, that there were thousands of calls, hundreds, if not thousands of calls, and they provided 80 or 90, whatever the hell it was, on a CD or DVD. So that's interesting.
They asked him to provide those if he hasn't already.
Yeah, that's right.
89.
That's right. They did. All right, let's move on. Interrogatory number 9. For each item of damages that you identified in interrogatory number 8, identify the amount of damages you are claiming and your method for calculating such a. Response number 9. Subject to his general objections, the plaintiff responds as follows. The damage to my reputation prompted me to retire from law enforcement 4 years earlier than I had wanted to, costing me at least $400,000. Jesus Christ. The value of the damage to my personal life, the destruction of my marriage, and loss of friends and family, personal health and well-being, sense of calm and sense of safety and security, and the general damage to my reputation, I'm requesting to be determined at trial by the jury. In my personal opinion, the value of $1 million per episode of MAM 1 and 2 would not even cover the loss of personal happiness caused by the defendants. Yet defendants have undoubtedly been enriched by at least that amount through what they took from me. So $20 million, if they go $1 million per episode, yeah, I don't think that's going to happen, Andy.
Million
episodes or just the episodes that he was actually in?
Yep. No. He's saying $1 million per episode.
$1 million per episode. Who the hell does he think he is? He's not that important. And I mean, I wish Sapper Cop was here, because do cops get paid £400,000 for being a cop?
Well,
Yeah,
it depends
but
on
when
the
he gets $100,000 a year and he can't even be bothered to write a report.
Yeah, I guess with overtime,
he wrote a lengthy report on Ramla when he arrested him.
I guess for, if you work a shit ton of overtime, a patrol or lieutenant could probably make $100,000 a year, but I think that's going to have to include a lot of overtime. I don't know what they mean.
You guys got to watch. There's a YouTube thing an investigative journalist did. It's called State of Unrest. It's about the Louisiana State Police Department. I believe it, or maybe it's not the state police department. Maybe it's a little jurisdiction there, but it's about a Louisiana PD department that is basically they're making more money than the mayor. And fraud of their job. So it's probably like a 4 or 5 part series, but they're very small parts. They're like 10-15 minutes per part, and it's called State of Unrest. So if you want to see how cops can make a lot of money just working overtime and stuff,
watch that.
Well, that's interesting you bring up Louisiana, because there is a woman on death row in Louisiana who was a cop. I believe her name was Antoinette Frank. She was a dirty cop, and she got with a younger guy, and she would get paid off the books like many of the other officers in New Orleans to like do bodyguard security for these restaurants in bad areas. And so she would escort the husband and wife to their car, I believe, when they would close, because they would have large amounts of cash. It was an Asian restaurant. And she told the guy about it, and the guy's like, let's rob them. And they ended up killing all of them, and one survived to ID her, and she got put on death row for it. But her case exposed a wealth of corruption in the New Orleans Police Department because of that same thing right there. And if we think back to what we learned through dispatch calls, Wisconsin has that same hustle. The dispatchers are on the calls talking. I think it's Stevie from Calumet talking about they asked if he could work overtime, and he's like, no, I can do 4 hours here, but then I got to go do 8 hours. I think he said it brilliant. So they're working multiple agencies all at the same time. They're pulling down retirement from multiple agencies all at the same time.
Well,
it's a hustle.
A lot of times these departments, they call on other agencies just to fill in overtime. They're not necessarily working for that agency. It's just they're filling in.
Yeah, no, but they were working, and the EMTs were doing the same thing too. The EMTs would work for the county, and then they'd also work for the cities. Now, yes, there are volunteer positions and volunteer firefighters and EMTs that do that. These cats were getting paid multiple agencies every week for that. If we could get a whole,
I think Colborn also worked for, what was it, the township of Francis Creek, or the village of Francis Creek. He had some position there. I don't know if it was a paid position, but he is working there, and he's working there with Zygmunt. Lynn Zygmunt's husband is like the president of the village of Francis Creek, while Colborn was like the cop, or like a constable or something.
Yeah, the municipal deputy. Like, they only get one cop because they're small, but they get money from taxpayers for that position.
Pay for that, I'm pretty sure.
Yeah, it's a job. Right? It's a job with a salary, and he's the only cop, so he gets that salary.
Even beyond that, though, even beyond that, though, even if it wasn't, volunteering or taking another position as a police officer or whatever, there's these other jobs, exactly what you just talked about in the other case, going and being, off-duty security at a event, those kinds of things. Absolutely. And they can make some damn good money. So anyway, thank you for that. That's a good point. So anyway.
Mark's joined us in chat. Hi, Mark. Thanks for joining us. He says a lot of cops are engaged as cops for private policing roles where the police department is paid by companies for police services. This generates a lot of extra revenue for cops.
Absolutely. Yeah. Thanks for joining us, Mark. And that's an excellent point. That does happen. Maybe not so much in a smaller town like Manitowoc County, but you got Green Bay that's right there. I mean, it's 40 minutes away, 45 minutes, depending on where you live. It's right there. Milwaukee is an hour and change away. So a couple of large cities, these guys can make extra money.
It's basically the same kind of concept as private military forces, right? They contract out, which allows them to kind of put a blanket between their liability because they're contracting it out, but then they're contracting it out to a third party that's employing their officers. So they're still in control of what's going on and they're still making money on it.
Well, and most officers are bonded anyway. They're all that shit's already done, and so that's automatic leg up for them, right? So anyway, all right, let's move on. Interrogatory number 10. Identify all persons with a knowledge of facts relating to the damages you described in the interrogatory number 8 and the substance of each person's knowledge. Response. Subject to his general objections, plaintiff responds as follows. I've discussed the facts of the damages detailed in my response to interrogatory number 8 with very few people due to my newfound inability to trust anyone. I disclosed those damages to my healthcare providers and to the law firms who represent me in this suit. I've also disclosed how ma'am damaged me personally to the law firm representing me in my divorce case. I further have disclosed how ma'am has caused me damage to the producers of an upcoming documentary convicting a murder during interviews with them. Let me read that again. I have further disclosed how ma'am caused me damage to the producers of the upcoming documentary convicting a murderer during interviews with them. Beyond that, I rarely, if ever, discuss how ma'am caused me damages. I instead only defend myself, my fellow deputies, my former agency, and law enforcement in general when asked or confronted about Netflix or the producers of ma'am or ma'am itself. Wow. So even talking about this to the documentary that he was exclusively licensed to, he talked about how this damaged him to them. Wow. That's going to be interesting to see when that airs, right?
Yeah. That's how they were able to depose BS from Wisconsin.
Well, they also found out about the text messages too. So her involvement. Yeah.
Where in ma'am do they say that he's damaged?
They're saying that
damaged.
Well, they're saying he's trying to claim that, at the heart of making murder, it damaged him. That was the effect of what they showed, And most of it was him doing his job. Yeah, that's right. That was him doing his job or things that he said publicly as a police officer. That didn't have anything to do with ma'am. And again, this shit about the testimony, it changed nothing. It absolutely changed absolutely nothing in my view, my opinion. And I don't think anyone else's either.
No, well, exactly, Jack. I mean, we've done the transcripts, the whole lot of the transcripts. We had different people reading different parts, lawyers, witnesses, everything. There is nothing different that was shown in the documentary to what is in the documents. If anything, the documents prove even more how shady his inactions were, because that's what it comes down to. know what his actions were, because he didn't do fuck all. You know what I mean? It's his inactions that he didn't do. Like writing a report 8 years after getting a phone call. If he can't remember, even though he testified that he couldn't remember whether that phone call was about Stephen or not. You know what I mean? But he writes a report 8 years later saying that it was about Stephen. So which is it, Colborn? So it's his inactions that have got him to where he is, nothing else.
Well, you know, another fact that they can't get around, there's absolutely no way they can get around it. They were paired up with these Calumet and officers, state patrol officers, DCI officers. Now I'm talking about Manitowoc police or county police. They were paired up with these other people. Yet out of everything that they did, we end up with a 22, 23 page summary of what Manitowoc did in their investigation. And I'm sorry, that is so piss poor. It's not even funny. Some officers didn't even write a report. Jacobs didn't write anything, and he was involved.
Herman either.
That's right. But Jacobs, as we've listened to especially the newer calls that we got, Jacobs was involved up to his eyeballs. He was all over the place.
Yeah.
So
and
well, that's because he was only assisting, intimately involved, only assisting.
What's that, Christine?
I just want to say once again, we now know that not because of Colburn's excellent report writing, but because of Rookie's dogged determination to get the dispatch calls, that Andrew Colborn called in the missing woman's license plate right after being asked by Wiegert or Rimmerker.
Rimmerker.
He had found out, if he had found out who those plates come back to, yes.
That's right. It was Rimmerker.
And he didn't report it. It was 3 hours after she was reported missing, and everyone involved had the attempt to locate with her license plate.
That's right. So, car description, license plate, or name, everything. All right, let's move on. Interrogatory number 11. Identify every healthcare provider you have seen for treatment for any conditions that you believe was caused by was caused or exasperated by making a murder. For each, describe the nature of the symptoms for which you sought treatment, the diagnosis you received, all the medications you prescribed, and all the treatments and therapy you received, and the dates of the treatments and therapy. So they're wanting to know his medical stuff. Response number 11. Subject to his general objections, plaintiff designates that he has previously produced healthcare records in response to this interrogatory, without waiving the confidentiality designations in said prior production, which are incorporated by reference herein. Plaintiff further responds that he has seen the following providers that he has seen for anxiety related to the effects of MAM. Teresa Kruger-Junk, NP of Privia, on December 28, 2018, noted as having, quote, presented for, unquote, anxiety. Follow up on June 28, 2019, which looks like 6 months later. Plaintiff has taken Bisoprolol, Buspar, as a result of his anxiety caused by MAM. Plaintiff believes that the stress is also adversely affecting his blood pressure, for which he takes lisinopril. Damages are ongoing, and plaintiff reserves the right to supplement his this response. And as we know, there is some newer filings, newer information that has probably got some of his medical information that's redacted. I don't have a huge problem with the redactions, but you know. Anyway, this is dated 20th day of June 22 from a law firm of Conway George Burnett's law firm. Yeah, here's okay. This is the table he was talking about earlier. And we can go through some of these. Exhibit A, subpar numbers, short basis for knowledge of falsity and or reckless disregard for the truth, otherwise reasons to doubt the veracity of information. See Anderson v. Herbert. Number 1, Avery Avery, quote, nobody said anything. And it looks like plaintiff's replies, obvious reasons to doubt the veracity of the informant. Avery, a convicted murderer who claims that he was framed. Further, accusations regarding the civil suit settled for far less than he was claiming, and the suit did not establish any liability for the allegations made. That's talking about the civil suit that Avery had. Number 2, Kim Ducott, dire warnings of alleged intent to retaliate for civil suit. Obvious reasons to doubt the veracity of the informant on the Avery relative and sympathizer who offers no apparent basis for her statements other than her own alleged intuition. Okay, yeah, I'm not going to go through all these. They're there, and I'm sure they're numbered. You can see the number that it's kind of like a footnote number, but it's directly tied to this chart. It looks like this chart runs. Yeah, this chart's pretty long. Yep. That goes down to page 14, and let's see what else we got.
Who made that chart?
Well, this is part of it's from Colborn's lawyers. I guess it's attached as part of the interrogatories from last year. Okay, this is another document, Exhibit A, Season 1, Episode 1. It looks like they've got some things that are, let's see, number 1, Avery. They had evidence back then that I didn't do it because nobody said anything. Number 2, okay, this is tied to the chart. Number 2, Kim Ducott, they weren't just going to let Stevie out. They weren't just going to hand that man $36 million. They weren't going to be made a laughingstock, that's for sure. So these are tied to that chart that we just looked at. And that's why that's how they responded to it. Instead of going underneath each one, they just made a chart. Yeah, okay. It's got Glenn in here. Yeah, I'm not going to read through all. Because some of the stuff comes from, or this stuff comes from Making Murder, either in one form or another from the civil depositions or otherwise.
I can't see the chart right now. I'm confused. What is this allegedly proof of in Colborn's case? What does this prove?
It doesn't necessarily prove anything. What I'm saying.
Well, what does he think it proves?
He's putting in stuff like Kim Duquette was the one I saw. She says something like, she says that they're never going to give him a free shake if he stays in Wisconsin or something like that. Like, so then he wants to say how, they're misrepresenting the truth because, Kim obviously doesn't have the right to think for herself.
Yeah, that's what I'm getting out of it. How dare he's trying to take the position that Making a Murderer shouldn't be allowed to interview people in the town about the police officers in the town.
That's right. And we talked about this yesterday. You weren't here yesterday, but Dr. Silkman brought up a great point. This is about, basically it's about censorship. You're not allowed to speak. Right. And, the truth is its own defense. And, if you can't have a differing opinion, we're done. We're absolutely done as a people. I mean, my God, man, just because I disagree with someone doesn't mean that we can't talk. I mean, come on. I mean, that's just the way the world has to work. But what they did, instead of going through underneath each one, like having a statement and then them answering directly below it, they created a chart to do it for them. So this Exhibit B summary, number of short description, how emissions changed ma'am made a false and substantial part. And the third part on this one is basis for inferring knowledge of falsity and or reckless disregard of the truth. Obvious reasons to doubt the veracity of informant or information. So they've got another chart in Exhibit B summary.
Now it's interesting. Let's remember now they use Kim Ducott as a snitch in order to search the what do they call that thing?
Smelter.
The smelter. So she's a reputable snitch for them to get to help incriminate Avery, but she's not a reputable person to say her thoughts on the Manitowoc Sheriff's Office.
Well, yeah, right. That's exactly what Dr. Silkman brought up yesterday. You say something negative, and here we go. Exhibit B. This starts off, ma'am takes testimony out of context, omits inconvenient portions of responses, splices testimony within. Yeah, this is something was filed previously that they're attaching. Again, I'm not going to read through all this. I'm just not doing it. We don't need to anyway. We've seen this stuff before. And actually, this is part of it. Looks like this is trial testimony. And that's the end of that one. So that's interesting that they did it that way. I would prefer to see them answer underneath each question what they mean, instead of putting it in this chart form. It's not confusing. It's just you have to go to two other places to find out what the hell they're talking about, and I don't like that.
They're probably.
It kind of reminds me of the chart that Kathleen Zellner made when she put out that questionnaire to the Gilters.
Yeah, but it was hers.
Like that whole what Kratz said about. He says Stephen Avery called Auto Trader and said she didn't show up, and we know it was Steve Speckman.
Yeah, but hers
actually held weight, whereas Colborn just seems to be a moron.
Hers was well put together and easy to understand. I mean, it was all kind of one thing, you could go to it and boom, you could understand it. This is scattered across three different, it's a chart, and then, the other documentation that supports it. So it's confusing to me, to say the least. They should have done it all together. It would have made for a long.
That's why I want to know who actually made it.
This come from Burnett, So
well, I'm sure it came.
Who was helping the lawyers and doing the research?
Exactly. Because I'm sure they got the idea to do it from Zellner, because they are definitely obsessed with anything to do with this case, and they don't have a lot of creativity skills. And I wonder if they didn't do it in this way because there's so little. They think that if they put it all together, it kind of makes it look like it's more, and it's more evidence, and it's weightier than what it is.
Yeah, they piled on. Yeah, I get what you're saying. Yeah. No doubt.
What document was that again?
That was document 279-51.
51. Okay.
Yeah.
Thank you.
And we're fixing to move on to the last exhibit in document 279, which is 52. It's exhibit 49.
49. Let's look
this is Colborn's supplemental response to Defendants Netflix's interrogatory number 1. It's a supplemental response to what we just read. So let's get to it. Yeah, this is July. Yeah. Okay. Plaintiff Edward Colborn, by and through his attorneys, supplements in response to Defendants Netflix interrogatory number 1 as follows. Supplemental response. In supplement to plaintiff prior response to Netflix interrogatory number 1, and subject to all objections asserted in plaintiff's prior response, plaintiff supplies the attached chart of the additional facts responsive to the interrogatory. So we got another chart to go through. This is now they're going to the Bates range, and of course we don't have the Bates numbers, so this would be a little difficult. We'll read the top one here just to kind of get an idea, and then we're probably going to move on. There's 8 pages, it looks like, of this. So evidence or supporting actual malice from which actual malice may be inferred. Yeah, we'll read this one, maybe a couple more. Lisa Nishimura advises on an incoming employee Adam Del Dio to think about decisions about the structure of the series, quote, from a marketing perspective, end quote, and, quote, to some degree, awards qualifying perspective, end quote, demonstrating that Netflix's goals in participating in the post-production process were to market the series and to qualify for awards rather than to tell the truth. Well, they're inferring that. You don't know that. Again, this goes back to making a product, a marketable product that's well received. Well, wow, that's what all companies are about, or at least those that are in the business of making money. So I think this is really a stretch. They've tried to make this connection that Lisa Nishimura and Adam Del Dio and that Benjamin Kottner directed the filmmakers what to do, but they can't do it. Not from anything that I've read so far. They made suggestions, and that's all. So, and that's on cuts that were already done, you know. This next one, 1906, Bates, status update from the filmmakers demonstrates that Netflix representatives had seen early assemblies and therefore were able to note changes, especially editing changes, as post-production occurred and between different versions of the episodes. Well, of course, there's alterations made. I think they're grasping. 1907 to 1930, Netflix representatives were aware that Laura Riccardi and Laura Moradimos were attempting to participate with Avery's attorneys in obtaining independent testing of the blood vial featured in the series in further efforts to aid Avery's defense team. There's no proof of that whatsoever. None. Again, I think that's more of a huge inference and without proof, because I haven't seen anything like that yet. Bates 199, Netflix representatives suggested changes to the series to augment the focus on Stephen Avery's voiceovers. Well, they might have, but again, there's nothing wrong with that. Anyway, I'm not going to read through every one of them.
You mean they voiced over like a picture of him when he was in prison and they couldn't actually get footage?
Possibly, yeah, probably. No doubt. I'd be on a phone call maybe with him and use that voiceover to, as something else was going on screen. Absolutely. That's common. That's common documentary filmmaking stuff.
Yeah, but just the next one, Jack, 202, 1940. Netflix representatives sought to find ways to have the series allude to possible planting of evidence against Stephen Avery, independently of any theories suggested by Avery's lawyers in interviews or otherwise. No, it was their friggin' actions or their inactions that made people think or allude to the possibility of planting. Like the cops, who is a huge conflict of interest all over the property, all finding crucial evidence. You know what I mean? What else?
I think that's
no
a
right
very good point. Is there was a conflict of interest. When I walked away from MAM, I saw a huge conflict of interest with the Manitowoc Sheriff's Department even being on that property.
Absolutely.
Yeah.
So that alone makes them look bad. They did that to themselves. When Peterson recused himself, he should have recused everyone in his department to be from that property, even the ones that were not actually being deposed, but especially the ones that were being deposed.
Absolutely.
So if he wants to blame someone for his actions or inactions that he had in this investigation that made him look bad through this whole trial, he needs to go sue Manitowoc.
Yeah. Because, as I say, it's their inactions of all of them that made us allude to the fact that they planted evidence. You know what I mean? So it's nothing to do with what the filmmakers edited or didn't edit or put in or didn't put in. Everything that was there, you can clearly see, as Nosy says, common sense, lol. Anybody with common sense can see that there's a whole conflict of interest. They should have been nowhere near the property. So no wonder people have got their suspicions when they are the ones that are finding the crucial evidence that sent Stephen to fucking jail for life. Period.
Well, the fact is that, I'm sure, hindsight being what it is, but I even with looking at hindsight, they shouldn't have been on that property at all. They should have brought in Brown County or a county that was much larger in nature, and they wouldn't have had to have worried about supplement. So, county like Brown County or Sheboygan, that's another large county. They could have probably handled the case along with the DCI, and Manitowoc wouldn't have had to been involved at all. Maybe, have some civilian employees provide, help provide food and that kind of stuff. But as far as connection
the only thing they should have had done in this case is pay for it, because it was in their county and they were responsible for that. Well,
that's a whole nother can of worms that Jinx has got. And oh my God, I'm sure she'll be covering that in a podcast, but oh my God, the money.
Put the documents in my community page on YouTube as well. I've put them out there. I haven't gone anywhere and talked about anything yet.
Yeah, but there are some really interesting things in that documentation, because if you look at that money, everybody had their hands in that pile for shit that's just, it's like, what? Like camera and video upgrades for the courthouse and the hallway. And there's just a number of things as you're just like raising.
That's all I've seen so far. Like I might have missed something in one of these little lists because they didn't actually provide, some of them don't provide receipts. They just, like Calumet County provided a list of what they were paying for, or whoever, but they don't actually, I haven't seen actually receipts for any of it.
Yeah, and that's right. And thinking about all the overtime, you would expect in a large case like this, especially in the beginning, where first couple of weeks, there's going to be a lot of overtime. 100 days later, these guys are still working a lot of overtime, a lot. And they weren't guarding anything. I mean, I don't know. You just got to follow the money. But that's a whole nother podcast. It's really interesting though. And I'm sure at some point, Anyway, go to Jinxie's page and check that out, the documents, because it's really interesting. Anyway, so this is the end of document 279 and the attachments. Oh, that's too bad. I hate that. Which means we're going to move on. This is document 2. We don't have document 280. It was withheld. But we do have document 280. And document 281 is Defendants Laura Riccardi, Moradimos, and Chrome Media LLC's motion to restrict. Now, this is a 9-page document. They'll have a volunteer to read. Anybody want to read this? Hint, hint. No.
Yeah, if I can find it, I'll read it. I'm just trying to find it.
Saw Susan poke her head in the chat on the YouTube. Maybe she's ready to go.
She's working. She's. I don't think she's in. She's not home yet. No. Do you have the link that I?
Yeah. I've got the line. I'm just trying to find the document.
Well, if it'd be easier for you, I can just put it right here in our Discord chat, and you can pull it. That work?
Yeah, do that then.
Once.
I'm curious how much the recreation of the Avery property, trailer, garage, etc. cost that they used in court instead of taking the jury to the property. Can't remember the guy's name that did it.
Yeah, that wouldn't have been cheap, but I mean that they did. I mean, it was just, $2.5 million, they spent it, some of that stuff. Some of those bills.
To ask DCI for their invoices, receipts, and such that they either paid or sent to be paid, and Calumet County and some of these other places that are like, I saw the Manitowoc fire department was a receipt in there, so I would like to see more of that. Those other agencies, we can ask those agencies for their copies.
I want to know who paid for Great Lakes Search and Rescue, but that sure as hell wasn't cheap. The number of handlers, the dogs, and a helicopter.
And we don't have those.
Nope, it wasn't included, and it should have been. That wasn't free. There's no way.
I mean, it is 17 years later, so they could claim they just don't have them anymore or whatever, but
that would be surprising. That much money. Yeah, that much money, that would be surprising. Anyway, Alice, I put it in chat.
I'm just trying to get it now. I've got 2 to 1. Defendants, Laura and Ricardo, Moira, Demos, and Chrome.
Yeah,
that's it.
Yeah. Yep, that's it.
Okay. Defendant Laura Ricardo, Moira Demos, and Chrome Media LLC's motion to restrict. Pursuant to Rule 5.2D of the Federal Rules of Civil Procedure, Civil Local Rule, defendants, Chrome Media, the producer's defendant, by and through their undersigned counsel hereby move for an order restricting exhibits 1 to 32 to the concurrently filed declaration of Moira Demos, filed in support of this motion to restrict the Demos restrictions declaration. The producer defendant so move based on the good cause demonstrated below and in the Demos restriction declaration. Footnote,
read that footnote.
Yeah, each of exhibits 1 to 32 is a short audio video clip, generally about 20 seconds each, of the proprietary raw footage belonging to the producer defendant's Demos restricted declaration as they are audio-visual files greater than the ECF system size limitations. The producer defendants are filing the exhibits 1 to 32 conventionally via Federal Express being sent today. The producer defendants also move to restrict with respect of exhibits 24 to 27 that will be attached to the declaration of Kevin Vick that will be filed via the ECF system in support of the producer defendants. Motion for summary judgment. The Vick MSJ declaration later today, although the producer defendants file this motion in compliance with Rule 79D as set forth below, the producer defendants take no position on restricting public access to exhibits 24 through 27 to Vick's MSG declaration, which contain materials that other parties, plaintiff Andrew Colborn and non-party Brendan Schuler, have requested that we not publicly file. The motion is based on this motion, the incorporated memorandum of points and authorities, and the support therefore, the pleadings and papers on file herein, and such other evidence and arguments as may be presented to this court. On September 7th, 2022, the parties met and conferred in good faith pursuant to Local Rule 79D4 to avoid this motion or to limit the scope of the documents or materials subject to sealing under this motion. The parties made significant progress and agreed to file voluminous materials conventionally, leaving only the exhibits addressed in this motion, at least with respect to the producer defendant's motion for summary papers filed concurrently herewithin. Memorandum of Points and Authorities. 1. Introduction. To protect the confidentiality of non-public and confidential information exchanged during discovery, the parties executed a protective order, which was entered on August 19, 2021, docket 30. On September 16, 2022, the producer defendants will file, among other documents, a motion for summary judgment, memorandum of points and authorities in support of their motion for summary judgment, a proposed statement of material facts, a supporting declaration of Kevin Vick, which will include exhibits 24 through 27, and a declaration of Moira Demos in support of the motion to restrict with exhibits 1 through 32. Collectively, these documents will seek summary judgments on plaintiff Andrew Colborn's Second Amendment complaint and each of the claims allegedly therein against the producer defendants. Certain exhibits attached to the Vick's MSJ declaration and exhibits 1 through 32 to the Demos restriction declaration, we provide in reliance upon and subject to the protective order in this litigation by plaintiff defendants and third parties who received document subpoenas from the parties to this litigation, specifically exhibits 24 through 27 to the Vick's MSJ declaration consists of documents and media produce in discovery that have been designated by plaintiff, defendants or third parties as confidential, pursuant to the protective order. In addition, exhibits 1 through 32 to the Demos restriction declaration consists of short portions of clips of much large audio-visual materials that the producer defendants produced in discovery and designated as confidential, pursuant to the protective order. Number 2. Argument. A. The court has the authority to allow the producer defendants to file documents as restricted. The presumption that documents filed with the court are considered public documents is a rebuttal one. Pursuant to Federal Rule of Civil Procedure 5.2d and Civil LR 79d4, this court may allow a document to be filed under seal or as restricted for good cause. See Nixon versus Warner Coms Inc. Every count has supervisory power over its own records and files, and access has been denied where court files might have become a vehicle for improper purpose. Courts may allow parties to seal or restrict documents containing sensitive business or proprietary information. See Baxter Intel versus Abbott. B. Good cause exits for allowing exhibits 1 to 32 to the Demos declaration to be filed as restricted. Exhibits 1 through 32 to the Demos declaration should be sealed because they consist of clips from larger audio-visual materials that the producer defendants designated as confidential pursuant to the protective order. Specifically, exhibits 1 through 32 are each short video clips, generally about 20 seconds each. The proprietary raw footage belonging to the producer's defendant's Demos restrictions declaration. As explained in the Demos restrictions declaration, exhibits 1 through 32 consist of portions of larger law audiovisual footage that the producer defendants either filmed themselves at significant personal expense and effort in the process of documenting Stephen Avery's 2007 murder trial, or obtained from Wisconsin television networks with whom the producer defendants collaborated as part of the media pool in connection with the 2007 trial. Demos Restrictions Declaration 2.4. With regard to the latter, the producer defendants also paid a significant license fee for some of that footage. 2. The larger raw audiovisual footage, from which exhibits 1 through 32 are excerpt, consists of materials that the producer defendants produced in discovery and designated as confidential. 3. The designated is as confidential because it contains non-public, confidential, and proprietary footage that the producer defendants went to considerable personal effort and expense to record or obtain, and they derive potential economic and professional value in it, and remaining confidential and proprietary. Should the producer defendants desire to prepare any future additional documentary or other works related to the subject matter of the footage, which consists of footage of plaintiff testifying at the 2007 trial, they will be in a better position with respect to other parties also interested in preparing potentially competing works related to the same subject matter if these materials remain restricted and are not made publicly available.
Wow.
Well, I'll tell you, I mean, I don't know. I'm sure we have some that are familiar with this, but we have others that are not familiar. Typically speaking, in federal civil trials, exhibits are public, period. Now, in this case and other cases as well, now, defendants or plaintiffs can request that something be filed under seal. And that has happened. We have a number of different things in this case already that are sealed. Number one being the 4,000 plus text messages between Brenda Schuler, Colborn, and Griesbach. We've been waiting for months for those to be unsealed, but apparently
now is that I hate to interrupt, but is that what Vic is saying, that Riccardi and Demos don't mind if it's unsealed? Are those, is it 21 through 24
I
where
don't know.
he highlights? I wonder if those are the text messages where they're only under seal because the plaintiff and a third party want them sealed.
I don't know.
Yeah,
I'm not sure if that's the. I'm not sure if that's those exhibits notes. I know this goes back to like document 219 or two. It was right around the 220 mark is when all this shit came up. This is back months ago. So I'm not sure if that's the ones he's talking about. However, in the situation that we're talking about here with the filmmakers, I would like to, if they would really unseal these, because it's got raw footage of what they shot or they obtained, otherwise obtained from other the news channels around Wisconsin. I understand why they want it sealed. I get it.
Well, go back up. They basically say it's footage of Colborn testifying in the trial, and they do not want. And now, read that the last paragraph Alice wrote or read. It says that the reason they want it sealed is because it's unreleased. It's him testifying, and they don't want Cam to be able to acquire acquire it by this lawsuit and then use it to make money.
Right. It's proprietary. I mean, they went to
Yeah.
they shot it or purchased it.
Yeah. Yeah,
yeah.
which is fair enough. If the money came out of their own pocket, you know what I mean? They've got a right to keep it. Basically, what they're saying is look, if we want to make her say a MAM 3, we can use some of this information, but because there is a competitor out there, they don't want that information being released.
Well,
That's what
yeah,
I'm looking at.
yeah. Well, I'm looking at it as a competitor that is attached to this civil suit, a civil suit where there has been repeated requests for unedited raw footage, and we know that the BS from Wisconsin is employed by a competing documentary that wants to produce and release a documentary to try and minimize and paint Making a Murderer and Stephen Avery in a disparaging light. So, and wow.
Yeah.
I mean, they basically just came out and said what we've all been thinking all along.
Well, I mean, we've talked about this a little bit before. Back, I don't know, it's been back several months at this point about, this other competing body being Transition Studios trying to get this raw footage. That's kind of been an underlying thing. It's always been there's the elephant in the room because they have it. You're right, Christina. They've asked numerous times for raw footage. It's scattered throughout pretty much the entire fucking lawsuit, pardon my language.
Yeah, and Burnett had a shit fit when he was told Netflix never had the raw footage, because
Correct.
that kind of blew a hole, I think, in his whole strategy of acquiring it. I think he had a game plan for how he was going to get it, and when Netflix never had it, that kind of put a big old hole in his ship of getting it.
I think that, like a lot of people, because I'll sit here as just as a consumer, just regular guy, when I watch a documentary on Netflix or Amazon Prime or whatever, in my mind, they had the raw footage in my mind. But that's as far as it goes. I don't know how that process works at all. And now it's been revealed clearly that all Netflix did was basically help finance and provided some other things, elements. I call them elements to help make the documentary more presentable, make it good, right? They didn't actually have the raw footage. The filmmakers kept it. And I understand why they would. I really do. Remember, guys, everybody has to keep this in mind. Kratz tried to take the raw footage back in 2006. They had to go to court. And, of course, the judge laughed him out of the courtroom. Can't do that. Yeah. He had no proof that they were hired by the defense or helping pass messages. He had nothing. He just wanted that footage.
Yeah. I think greed is always been at the heart of this case.
Well, yeah. Anyway, all right.
I think greed's been at the heart of the Teresa Halbach case too, personally.
Yeah. Colette, you're saying that the document's blurry. What you might have to do is, whether you're on your phone or your laptop, if you go to the cog.
Yeah, go to the gear.
Settings. Yeah, the wee gear. If you go to that, go into settings and click your quality. Click on that. Then click on advanced settings. And then change your viewing to
HD 1080.
Yes, 480, 720, or 1080p, and that should clear up your screen.
I'm streaming HD.
I just did that.
Yeah.
I just did that because mine was blurry. Mine was set on 420. I just changed it to 1080 and I'm looking at a crystal clear photo.
Yeah, I'm streaming in 1080. It should be crystal clear.
Yeah.
It does that with me sometimes as well. It goes blurry, and it just means you have to go to the cog, and depending
Change
on
the quality.
It gives you the 1080. But normally it's 720 or something like that, and that should clear up the screen.
Hey, I gotta ask. Hold on, Alice. Are you saying cog, like COG, like a cog in the wheel? That's funny.
Yeah.
That's right. That's what they call it. We call it the gear. They call it a cog, but it's the same thing.
Yeah.
Yeah, it's a gear cog, guys. So we call it a cog.
That is funny.
All right, Alice, continue on.
Okay. This core is
wait.
empowered.
Let me finish my thought. I apologize, and I'll let you continue.
No, on you go.
As I said, and Ludwig has said this at least twice that I've heard, he does not like to seal documents. He wants it public, everything. But given this situation here, I can understand why the filmmakers would want it sealed, and I understand why Ludwig would allow it. So there we go. Off you go now.
This court is empowered to maintain this footage, quote, under seal where public disclosure of the information would effectively afford other firms an unearned competitive advantages, unearned because the issue of public disclosure arises from the advantageous circumstances of the documents having become caught up in litigation and as a result having become filed in court.
You don't have to read all it. You don't have to read all those citations.
Right. Granting motion to seal. Oh, wait a minute. Granting motion to seal where the sealed exhibits and filings in that case referred confidential, non-public propriety and competitive information regarding the parties' business operations. Granting motion to seal surveillance footage where permitted public viewing would pose a security risk. Public release of exhibits 1 through 32 would lead to an unearned, quote, unearned competitive advantage, end quote. Here, for several reasons. First, the majority of exhibits 1 through 32 comprises raw footage that defendant Demos captured herself and therefore constitutes the producer-defendant's own intellectual property over which they have the exclusive right to reproduce, distribute, and display publicly. Demos restriction declaration, the producer-defendant here have made the concerted decision not to grant any third parties any rights in this under-sealed footage, which is their right and prerogative under, among other things, the Copyright Act. Second, the remaining portions of exhibits 1 through 32 contain raw footage that the producer-defendants license for a substantial license fee, Demos restrictions declaration. If this licensed footage were made public, that disclosure would destroy the value of the producer-defendant's license. Additional reasons for concern. Finally, 1 through 32 are material that is protected by state and federal journalists' privileges and shield laws. See Wisconsin Statute 885-114 and the Wisconsin Constitution. 1 through 1 through 18?
Let's
16?
see.
1 through 16?
14.
14?
Yep.
1 through 14. I'm no good with the bloody numerals like that. While the producer-defendants have not relied on such privileges and laws to restrict plaintiffs, and his counsel's access to the footage in light of this litigation, they have not and do not waive any of their rights under those privileges and laws with respect all other parties. Demos Restriction Declaration 6 that further justifies the material remaining restricted. C. The producer defendants take no position or propriety for sealing Exhibits 24 and 25 to the Vic MSJ Declaration. Exhibits 24 and 25 to the Vic MSJ Declaration are certain of plaintiff's medical records that he produced in this case and designated as confidential. While the producer defendants believe that the plaintiff has put his records directly at issue in this case by bringing a claim for intentional infliction of emotional distress, they take no position as to whether good cause exists for the records to remain restricted. The producer defendants previously communicated with plaintiff's counsel about the producer defendants' intention to file the records in connection with the summary judgment, and plaintiff's counsel requested that the records not be publicly filed. D. The producer defendants take no position the propriety of sealing Exhibits 26 and 27 to the Vic MSJ Declaration. We are informed that Exhibits 26 and 27 to the Vic MSJ Declaration are to interview transcripts from an unreleased counter-documentary bearing the working title Convicting a Murderer that were produced in discovery by Brenda Schuler in response to a document subpoena from defendant Netflix. We are informed that Schuler is plaintiff's close confidant and the executive producer of Convicting a Murderer. The producer defendants previously communicated with Schuler's counsel about the producer defendants' intention to file the records in connection with summary judgment. The plaintiff's counsel requested that the records not be publicly filed.
That is interesting. Wow. So they filed subpoena with Brenda Schuler to produce certain video footage that she has provided to apparently Attorney Vic, and they're not going to argue if they want it sealed.
It sounds like it was Andy's interview.
There's Susan. Oh my God. Well, welcome home. Welcome to the chat.
Thank you.
How was work?
Yeah, it was work. I got her done.
There you go. Hey, thanks for coming home and joining in.
Sure.
So yeah, this is an interesting document actually. Anyway,
did it not say that was Andy's interviews? Is that what it was at the top? I can't see it.
The defendant, yeah, or not the defendant, the plaintiff.
Yeah.
We're informed that the 26-27 declaration are two interviews, transcripts from the unreleased counter documentary bearing the title "Convicting a Murderer" were produced in discovery by Brenda Schuler in response to a subpoena from defendant.
I bet those were Andy's interviews. Mm-hmm.
Is plaintiff's close, and they also mentioned plaintiff's close confidant and executive producer tied at the hip.
But I thought Rick was the executive producer.
He's it's his project.
So should she not be assistant executive
producer? No.
You can have more than one executive producer, actually.
Absolutely.
Executive. Yeah, executive just simply means like monetary, because I learned that from Alex Baldwin. Like, he was an executive producer on the Russ movie.
Yeah.
Which means that he put money in to help it get made.
Yeah.
Right.
That was what he said anyway.
I'm
She
sure
just
those
Right.
interviews are just sappy and puke worthy.
She just mentioned it.
No.
Oh, wait.
Website.
Look at me.
What-
Oh, look
what-
at me. It's my life.
What's that, Jinxie?
I said on the website for Transition Studios, she's just listed as a producer, not an executive producer.
Yeah, but I think originally that she was just a producer, and then that role grew over time. After Kratz found out that it wasn't his project.
Rec is the co-founder, CEO, and director.
There you go. All right, Alice, read the conclusion.
Okay. Number 3, conclusion. The producer defendants respectfully request that the court grant this motion to restrict as to exhibits 1 through 32 to the Demos restriction declaration in support of this motion to restrict, as those documents contain commercially sensitive information and the disclosure of which would prejudice their interests. The producer defendants take no position with respect to exhibits 24 through 27 to the forthcoming VIX MSJ declaration in support of the producer defendants' motion for summary judgment, dated September 16th, 2022.
So this is a recent filing from them. And I understand it. Again, I'd love to see the raw footage, but I understand why they want it sealed. I get it.
Sure.
Yep. So that's the end of document 281.
We'll see it in MAM 3.
Maybe. Let's move on to document 282. Susan, you feel like reading, or are you still catching your...
Yeah, I can read.
Okay,
Document 282.
Yeah, this is just a 2-page document. This will be a quick one.
Okay, I'll just read it off of
Off the screen.
off the screen. Yeah.
Sure, go for it. Can you read that, or I need to blow it up?
Oh, I can read it. It's fine. Defendants Chrome Media LLC, FKA Synthesis Films LLC, Laura Riccardi, Moira Demos, motion for summary judgment. Pursuant to Rule 56 of the Federal Rules of Civil Procedure and Local Rules 7 and 56, defendants Chrome Media LLC, formerly known as Synthesis Films LLC, Laura Riccardi and Moira Demos, collectively the producer defendants, through their undersigned counsel, respectfully move the court for an order granting them summary judgment and dismissing plaintiff's entire operative complaint against them and all claims therein with prejudice. The grounds for this motion are set forth in the accompanying brief. Proposed findings of facts, the declaration of Kevin Vick in support of the producer defendant's motion for summary judgment with its attached exhibits, the declaration of Laura Riccardi in support of the producer defendant's motion for summary judgment with its attached exhibits, the declaration of Moira Demos in support of the producer defendant's motion for summary judgment, the separately filed declaration of Moira Demos in support of the producer defendant's motion to restrict, the audiovisual exhibits to be physically lodged with the court, and the parties' stipulations of facts as filed by co-defendant Netflix Inc., the pleadings and records already on file with the court, and any oral argument permitted by the court on this motion. Dated September 16, 2022. Respectfully submitted by Kevin Vick.
Well, there you go. And I will tell you all that I didn't read through all of it. We'll move on to document 280. Yeah, this is a 3-page document. The brief that they filed, as I scanned through it, again, I didn't read all of it, but basically it's the same one that Lita Walker filed. And I just don't see the need of spending another hour reading a document that's basically the same thing. And we can scan through it, and We can scan through it quickly and see if there's anything of interest that may possibly be different, but I don't think there is. So anyway, you can go ahead and this is a 3-page document. So if you want to read this one too, Susan, this declaration of more demos in support of motion to restrict.
Sure. I, Moira Demos, under penalty of perjury and subject to 28 U.S.C. 1746, declare as follows. 1. I am co-creator of the documentary series Making a Murder and co-founder and co-owner of Chrome Media, LLC, FKA Synthesis Films, LLC, with Laura Riccardi. I submit this declaration in support of the motion for summary judgment filed in the above captioned matter on behalf of myself, Laura Riccardi, and Chrome. I am over 18 years old and have personal knowledge regarding the facts set forth in the declaration. I offer this declaration in support of the producer defendants' concurrently filed motion to restrict, docket 281. Number 2. During the process of documenting Stephen Avery's 2007 murder trial, I personally recorded portions of that trial at significant personal expense and effort. Also, as part of the process of documenting Stephen Avery's 2007 murder trial, Riccardi and I obtained additional footage from Wisconsin television networks with whom my co-defendant and filmmaker partner, Laura Riccardi, and I collaborated as part of the media pool in connection with that trial. Riccardi and I paid a significant license fee to obtain that footage from those television networks. Should Riccardi and I desire to prepare any future additional documentary or other works related to the subject matter of the footage, which consists of footage of plaintiff testifying at the 2007 trial, we will be in a better position with respect to other parties also interested in preparing potentially competing works related to the same subject matter if these materials remain restricted and are not made publicly available. During discovery in this case, the producer defendants produced certain of such footage discussed, specifically all of the raw footage we have of plaintiff testifying at Stephen Avery's 2007 trial for the murder of Teresa Halbach. Because that footage is proprietary, we created and obtained it at great personal effort and expense, and have not otherwise shared it with others. We marked it as confidential under the terms of the protective order in this case when we produced it in this case. Number 3. In preparation for and for use with the producer defendant's motion for summary judgment, docket 282, I personally prepared 32 short audio-video clips, generally about 20 seconds each, that represent portions of the larger footage of plaintiff testifying at trial discussed in the previous paragraph that we produced in discovery in this case. Attached here too, as Exhibits 1 to 32, are true and correct copies of those clips that I prepared. As is reflected in Exhibits 1 to 32 themselves, they bear Bates numbers reflecting the larger audiovisual files from which they are taken that we produced in discovery. The import of and context for Exhibits 1 to 32 will be addressed in detail in my declaration that will be filed later today in support of the producer defendant's motion for summary judgment. Number 4, public release of Exhibits 1 to 32 would lead to an unearned competitive advantage to others for several reasons. First, the majority of Exhibits 1 to 32 comprises raw footage that I captured myself and have never publicly released, published, or displayed, and do not currently intend to release, publish, or display in the future. Number 5. Second, the remaining portions of Exhibits 1 to 32 contain raw footage that Riccardi and I licensed for a substantial fee from Wisconsin television networks, with whom we collaborated as part of the media pool during the Avery's 2007 murder trial. If this licensed footage were made public, that disclosure could destroy the value of our license in that footage. I am therefore concerned that the public release of Exhibits 1 to 32 will frustrate my desire and intention not to license that footage for use in third-party documentaries. Number 6. Finally, Exhibits 1 to 32 are material that is protected by state and federal journalists' privileges and shield laws because it is unpublished material gathered in the course of Laura Riccardi's and my gathering of material for potential use in a documentary or other work. While Riccardi and I have not relied on those privileges and laws to restrict plaintiffs and his counsel's access to the footage in light of this litigation, we have not waived and do not waive our rights under those privileges and laws with respect to any third party. I declare under penalty of perjury that the foregoing is true and correct. September 16th, 2022.
I think that pretty, thank you, Susan. I think that pretty well spells it out. Yeah. And I wrote this down here, and I don't know if Cherie is still here. Hold on just.
Yeah, basically spells it out that the footage that they've got could be used against them through convicting.
Well, not against them, but they'd be using footage that they could be using or get this footage that was publicly released in their documentary that they didn't have to pay for.
Exactly.
I find it interesting that they pay for it. They haven't yet released it. They didn't have a problem turning it over for purposes of litigation. And all they're saying is you're not going to use it or you're not going to take it and then use it to make money on it.
Correct.
Or anybody. Yeah.
Yeah. Hey, I've got a question for Cherie if she's still here, and it was mentioned in the prior document, and this statute 885.14. Did you by chance catch that and look it up or no, Cherie? If you didn't, that's fine. I'm just curious as to what, and the reason I bring this up, I was talking to Jinx the other night, and we've been bantering back and forth, and she could come in if she wants about the videos. And not just, I mean, there's a number of cameras that we become aware of, but specifically about, because I dove into this some months ago, and I did quite a bit of looking as best as I could, and actually communicating as well. And I'll explain this just briefly. What I was looking for and what I wanted and was prepared to buy was Brendan Dassey's January 10 post-conviction hearings. It was five days or whatever it was. And I was told they don't have it. And I was told that by the clerk, Barbara Pimperin. They don't have anything like that, which I find really, really amazing.
Why wouldn't they have that?
Well, if it wasn't shot in Manitowoc, they might not have footage.
Some of it,
I don't.
Some of
Go ahead.
those video things that we see in the receipts is for Simplex Security or whatever, and they are talking about video for the hallway of the jury and the judge.
Yeah.
And this is around February something. So I'm thinking that maybe that's for Stephen's trial and not necessarily Brendan's. So that would be a different courthouse. It would be the Calumet County Courthouse.
Correct.
And not the Manitowoc County Courthouse. However, there is another charge from Simplex later. I think it's actually in might be in May, but I don't know what it's for. But they charge it to the Avery case, and it's more video stuff. And there was another one for like $6,000 or $7,000 or $9,000, but I don't remember what date was on that one. So if there was one in like May, then you would assume that they also did the same thing for the Avery or for the Brendan trial at Manitowoc. But I'm not quite sure I'll have to double check on that.
Well, there's another thing
like broadcasting, like because there was so much media there, wasn't there like a way for these medias to like sit in another room and watch the trial? And then if that was the case, why wouldn't they pop in a VHS tape to record the trial as it was happening if they're broadcasting it to another room?
Yeah, I remember, I don't know where the documentation is. I guess we could probably dig and find it, but I remember there was some discussion about the media room. I don't remember exactly the dates of it, but it was pre-trial, and they were talking about someone being in there to manage the cameras, and Laura and Maura volunteered to do that for not only themselves but for these news organizations.
I've never seen that document. I would love to see that document.
Yeah, I'm guessing this is probably not a large room. Probably a small room that's set near the courtroom where they could observe, and I think
it's in MAM. I think you see it in MAM.
Yeah, because don't they come into that room and talk to people like in both counties? Like they have like after the court hearing, they go out and they talk. Like you see Kratz saying whatever, and then you see Norm gone. Of course, it's okay to deviate from protocol when you're trying to make sense of it all. Wasn't that in the media room?
Yeah, it's like the public relations center of they have them for the sheriff's department, and they have them for the courthouses. It started prior to September 11th, but after September 11th, when they started having multiple press conferences, when they would do trials and stuff like that, the agencies got funding to actually designate rooms in the courthouses, rooms at the sheriff's department.
Yeah, media room.
Media relations. Yeah.
But anyway, going back to trying to get this footage for the hearing for Brendan's post-conviction stuff, and me trying to get this footage. Anyway, in my digging, and I gave this document to Jinx as well, there are rules within Wisconsin about video, and I don't know. I don't think it's in this document. It may be. I'm sure it's in another document, and I'm sure I read this. I can't produce it right now, but as I recall, this other document that I read, and it's a legal document, that the judge makes an entry about when video footage would start and when it gets filed. And I can't find any such documentation anywhere. I looked in the compilation. See, if you look at, if you go to Brendan or Stephen's compilation of their record, it lists pretty much everything that happens in their case. Instead, a lot of it's non-public. It's just things that happen, filing or granting an open records request, that stuff, that simple, to, filing a brief or some kind of motion. Everything is listed by date. And I can't find anything about them video recording these.
I know that. Have you checked? Because I know when Zellner took the case, they did a motion to correct the compilation of the record. I wonder if it was in there.
But the correction would be listed. This is looking at the Wisconsin civil or court system. You can go directly and look the compilation of records up for anyone in Wisconsin. I don't know that every state's like that, but Wisconsin it is. So this is looking directly at what they have on file that's publicly available right now.
Yeah, anyway, but we know that those are not always accurate. Because there will be cases, there will be documents that aren't listed. I wonder if we could.
Well, no, documents. Certain documents may not be listed, but if there's a motion filed, it's listed, and there are other things. But my point is that I can't find anything from Willis or Fox that shows video is to be. And see, the document that I remember reading, it said that the judge gives an order as to when the video documentation is to be filed. But anyway, in all this looking, I did remember this one as well. This is blah, blah, blah. Supreme Court Rule, Chapter 61, rules governing electronic media and still photography coverage of judicial proceedings. And I'm not going to read through all this, but it's an interesting document. It talks about, somebody gets elected as a media coordinator, blah, 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 equipment. So it gets in here where you can, what equipment can be used. They can't change lighting. They can't make noise. It goes into a lot of different things. But, my point being is that I understood that both trials were recorded. We see the footage in Making a Murderer. So I guess my bigger problem is having this as a part of our legal system, and it was recorded, and only a few people are allowed to access it to present to the public. You understand what I'm saying?
We should have access to it. Yeah.
But apparently we don't. They see that's my problem, and that's why I run into
Yeah.
and it was like running into a brick wall. Like, go ahead.
So is that why you're asking about that certain statute to see if it is publicly available information?
Yeah, 88514 was mentioned in the prior document, and I wrote that down because I don't remember seeing that, but that doesn't mean anything. I looked up so many of these. I can't keep every one of them straight. See, it even goes
different when it's cameras for court security and media, like for them to bring in their cameras and record a trial.
Possibly.
Because I see on Manitowoc Gov, they have HD security cameras in courtrooms. I don't know when they put them in, but it says all 3 circuit courts and the B15 courtroom are outfitted with HD security cameras to allow monitoring of the courtroom activity by the judges, judicial assistants, clerk of the court, and bailiffs in remote locations.
Yeah. Yeah. And here's another one that's interesting. SCR 61.09, official court record. And I found this really interesting. And this is another reason I would like to have all the raw footage. Because now, don't just, not even thinking about someone making a documentary. Think about the person that does the transcript. And so they're relying on something. Are they making their own recording? But anyway, let's read this one here and we're going to move on. Official court record. Notwithstanding any film, videotape, or photography or audio reproduction made in a court proceeding as a result of this chapter, the official court record of the proceeding is the transcript of the verbatim report of the court reporter made in open court or pursuant to an order of the court. So they're basically saying the official record is the transcript done by the court reporter, unless you have a video, because it says notwithstanding. So anyway, I thought this was an interesting point because we can't seem to be able to get a hold of any of the video that was made during the trial, pre-trial, whatever the case may be. So anyway, I thought this was an interesting, I just thought of this as we were going through these 2 documents and us discussing it. So I wanted to bring.
I would love to watch the entire trial.
Oh, God,
raw
yeah.
Footage. Yeah.
Absolutely. So anyway. Alice, did you by chance see any questions or comments that we need to get to before we move on?
No, but we've had couple of new people join us. We've got Dozer, who's joined us. We've got Disco in the house. And we have M4SYM, who's joined us. So thanks very much for joining us.
Yeah.
S4SYM says, no blood in the house of Stephen, no DNA, nothing of Teresa in the garage. The same. Why there were bones in both barrel pits. This is a case most strange I have ever seen. And then they say they framed the poor man and nephew for not to pay their demand. I don't understand why they don't give a second trial after all of this. And I just replied, because the state can't admit that they've got it wrong again. You know, they just can't bring themselves to do that. And then he is asking, why did they not search Bobby's garage? And I was like, well, that's a good question, and we don't know. I mean, we wish we knew, but we just don't.
Yeah, we talked about that one actually a few weeks ago. Dr. Silkman made a really good point, and other people as well. You know, this deer that apparently got killed by a deer strike with a car. You know, he had hanging in the garage, and there was one photograph, which is really strange, showing the tag that they got for that deer, that Bobby got for that deer. Who photographs their deer tag on a specific date like that? I don't know. It may not mean anything.
Narrative.
Well, it may not mean anything at all, and I don't want to put any kind of innuendo out there that says that it does. It's just another oddity of this case. Why that was done, and I can't really
out about that, to be honest. Like, they took the deer down and took a picture of the tag to make sure. Like, I mean, there is a bloody mess there, right? So why wouldn't they take a picture of that to make sure that it was something that was, legally done or whatever? Maybe that was their way of doing that.
Well, maybe that's true.
I do believe there is a report for that deer hit on the 4th, right before.
Well, there is a dispatch narrative report, which is 8844. I believe that's the one.
Well, I'm saying there's actually a report for this incident that you can actually get from Manitowoc County, an incident or it has a case.
I think we have it for the deer.
All right, but it's from on Jambo Road and 147 right by the house there on the 4th. And there's, I think it's like 8869 2005 0000 8869, I think is the number. So I think we should get that record just to see what's in it.
I don't remember if we've got 8869.
I don't know if we brought it up already. I had to step away for a minute. They also didn't take any blood samples from the blood in the garage either.
No, they didn't.
In the Dassey garage. The only site of any kind of bloody violence to any living being, and they didn't even take a sample to see if it was human blood, much less a sample to see whose blood.
Nope.
James, are you saying that either Barb or Bobby called in the deer?
No.
I'm saying that when somebody hit the deer, whoever it was hit the deer, called it in, and
That's right.
Oh, the person that hit it. Okay.
In Wisconsin, if you hit a deer, you have the right to claim that deer before anybody else. So that person had the right to claim the deer. So Bobby probably got out of the car and said, "Do you want the deer?" And they said no, and they said, "Okay, we'll claim it." That's what I think.
Well, I mean, according to what Barb has said, she saw the deer strike and called Bobby, but as a separate issue, that person called and reported it.
Somebody has to claim it. So basically, that it's not a tag; it's like a claim. It's a claim ticket.
Well, they tag it to determine that it wasn't killed illegally. That's it's a
tagging it. It's a DNR tag.
Right, because in order, so the way it works from my understanding is you have to pay to get a hunting license, and then you're allowed to hunt whatever at certain times, certain sizes. So if an officer was to come on your property and see a deer, and let's say you don't have a tag, you can be criminally prosecuted for that.
Right. You're given so many tags, or you're, you can, like in this case here, I think Jinx is right. This person that, this deer strike, however it happened, called us because there's a second part of this. They called and reported the incident. And then for insurance purposes, if their car was damaged, they go down the next day and say, "Hey, I got reported an incident, deer strike. I need to pick up the paperwork for their insurance." And that's basically pretty much it. Because it's a very common occurrence here in Michigan. I'm sure in Wisconsin, Minnesota, all the northwestern states, it's really common.
Even in Florida, there's lots of deers getting hit by cars in Florida too.
Absolutely,
they're everywhere. Yeah.
Absolutely.
Yeah.
I see Henbury has joined us. Hi, Henbury.
Hey there, know your rap guy. How's it going? Down under. Down under. All righty, folks, let's move on. This is a one-page. This is document 284. This is plaintiff's motion for partial summary judgment. Please take notice that the plaintiff, by and through undersigned counsel, hereby moves this court for partial summary judgment pursuant to Federal Rule of Civil Procedure 56 as to the issues on the ground set forth in a brief submitted herewith. This was the 16th of September, so basically a week ago or whatever. And this is from April Walker. So if you all will give me about a minute, we're going to pull up a few more. I don't know how many of those we'll get through, but let's take a look at them. Give me just a moment, and you guys can chat or whatever.
You're gonna lose. You're gonna
I do believe that it's probably going to be dismissed. Now, I wonder if it is dismissed, will the judge order the sealing and unsealing of certain documents as well? Is that how it normally works? Does that happen at that time?
We'd have
Say
to,
that again.
she wants to know if
So,
summary judgment is granted, will the judge unseal the stuff that's been sealed so far? At
Wait,
least some of
if a summary judgment is granted, if he grants it, will he also at that time seal or unseal these exhibits that are being discussed?
The ones that are the film of they probably never released those
Yeah.
footage.
And I'm okay with that. I want the text messages. I'm not going to pretend.
Yeah, so do I.
Oh, yeah.
It says, and why was there Teresa's blood in the raft if the crime was committed in the house in the garage? There is no point in committing the crime in the house, uploading the body to the raft to take it out again to burn it in the burn barrel. Exactly. I mean,
Hey, you know what we should do? If we're ever able to all get together, we should do a skit of the narrative presented of the crime. Like the hauling out, putting her on the mechanic creeper, taking her to the raft, getting her in the raft, going and creeping around the salvage yard, coming back. I wonder if the Averys would let us do that, to actually highlight
I'm
how.
gonna say no.
Yeah, probably wouldn't at this point.
Yeah.
They don't even like when you come up anymore to see
Money talks.
You know, that trailer, I believe, is falling apart too. I'm not sure if it's condemned or not, but it looked pretty bad off.
The last photo I saw,
when I was there.
Last photo I saw looked awful.
Yeah, I wouldn't. Well, we wouldn't actually. We could probably do the bedroom in another location. What I would like is to be able to drive the supposed route. They had Brendan say him and Steve drove, remember, because they say that they go down, the pond's not deep enough, so then they take her back, then they unload her, and then we can like superimpose on the screen Eisenberg's report showing the body dismembered, but yet that's not part of any story Brendan told. So where did that occur? And then have her put whole into the fire pit. I think it would be a huge way to kind of drive home just how absolutely absurd this story is.
Oh, the visual representation, absolutely. It would be a very, very impactful thing. But yeah. All right, folks, I've got documents. I've got several, starting at 285, which is 86, 87, 88, 89, and we do not have document 290. That was not part of what we could get, so it skips. I apologize for that, but there's really nothing way that's really out of our control. Anyway, let's continue on with this is. Let's see. Yeah, I think this is. Well, it doesn't say here at the top, but I think this is. Yeah, this is Chrome Media. It does say. This is their brief in support of plaintiff's motion for partial summary judgment. This is only a 17-page document, so I think we should read this one. The larger one, I know that exists. We're not going to read it because I think it's right around 40 or 50 pages like the other one that Lita did, and I think it'd be pointless to read it. I'm going to start this one off, give the ladies a break, and then maybe I'll trade off here partway through and let one of them finish it up. So anyway, introduction. Plaintiff brought this action against Defendants, Netflix, Inc., Chrome Media, LLC, Laura Riccardi, and Maura Demos for damages that their Making a Murderer series caused him after it was broadcast on Netflix. In this motion, plaintiff requests partial summary judgment on a few discrete issues, including 1. Defendant's publication of MAM, 2. The defamatory nature of republished third-party statements that were included in MAM, and 3. Defendant's actual malice as to the established third-party or published third-party statement. Plaintiff does not contend that the republished third-party statements are the only components of MAM that defamed him. Plaintiffs bring this motion as to those statements because the defamatory nature of those statements and defendant's actual malice regarding them can be decided as a matter of law, which is not the case for the broadcast as a whole.
What the hell? He's talking about what the people in the bar that are making these statements about him.
Yeah, that was part of that. Yep, that was part of what we went through yesterday. Absolutely.
Jesus.
So nobody can have a fucking opinion. I mean, come on.
Right.
All right. Material undisputed facts. There was no dispute that the defendants published, quote unquote, Making a Murderer series. Proposed undisputed fact number 1, docket 181, Netflix answer, and you guys see that. The broadcast contains numerous statements from individuals identified in the series as Stephen Avery, Stephen Avery's family members, Stephen Avery's attorneys, that individually or collectively imply or insinuate that plaintiff or a group of law enforcement officers that included him planted evidence to frame Stephen Avery for undisputed fact numbers 2 through 54 for brevity. The statements are not repeated here because they are included in a table herein at pages 6 through 12. In addition, bar patrons whose identities are not provided in the series are featured in the series as making express accusations that Manitowoc County law enforcement officers framed Avery. At least some of these individuals are shown playing pool with Avery's brother. Proposed undisputed fact number 61.
So?
Right, exactly. Number 61, Barclay Declaration. Stephen Avery was convicted of a murder in 2007. Proposed undisputed fact number 58. Plaintiff has denied in sworn testimony that he planted evidence to frame Stephen Avery. Proposed undisputed fact number 70, Barker Declaration. The Netflix representatives of the creative team that participated in the production of MAM reviewed and approved the final versions of all episodes of MAM prior to its being published. Proposed undisputed fact 59, Barker Declaration. Netflix series notes advised Chrome to use Ms. DeCott's statement that the county was, quote unquote, not done with Mr. Avery to impart, quote, a more explicit ending to an early episode that makes it clear that in the next episode the cops are going to seek revenge, unquote. Proposed
oh my God.
I know. Proposed undisputed fact number 71, Barker Declaration. Netflix representatives are also endorsing Netflix representatives also endorsed using Avery's father's statement, quote, "They framed an innocent man just like they did 20 years ago," end quote, as a quote unquote cliffhanger, proposed in disputed fact number 72.
Well, Pa Avery really believes that. So why can't he state his
Right.
thoughts?
Absolutely.
Exactly.
Just because they got a conviction doesn't mean that Pa Avery even changed his mind about it.
And not only that, they refused to participate in the production of the series. That's their fault.
Hey, and you know
And
what
I
else?
They knew about back in 2006 when they tried to sue for that footage. They had all that opportunity to participate for years.
You know what? Yeah, you know what else is interesting that just dawned on me? We know about several other cases of questionable police conduct, and did they mentioned the Ricky Hostetler case, right? They didn't mention any of the other ones.
Which
I
other one?
actually don't know if they mentioned the Ricky Hochstetler case in MAM. I don't recall that being in MAM. That was something we learned outside of MAM.
Yeah, I don't think it's in MAM.
Talked about Siegfried in his email and how the public believes this theory and stuff. That theory I don't think was in MAM either. That was something that was on a blog that Farrick eventually wrote about.
Okay.
Griesbach wrote about it.
Yeah. Did Griesbach write about it? So
it's in one of his books.
So here they're trying to make you think that they are partial to Stephen Avery, but yet they're not even mentioning all these other questionable cases, which would definitely give the viewer a wider lens at which to judge Manitowoc Sheriff's Department.
More suspicion. Yeah.
Yeah.
Right. And hell, who knows what could happen down the road, right?
So baddies.
Yeah. Anyway, all right, moving on. Defendants referred to those associated with Manitowoc County law enforcement as, quote, unquote, the baddies, for whom a specific, quote, unquote, bad guy theme music was to play during their appearances as part of the overall, quote, unquote, thriller atmospheric score, proposed undisputed fact number 72 and 73. It goes on to list the citations. The production notes also include a suggestion that the source material be reviewed for the purpose of finding material to, quote, allude to the fact that the cops may have planted something, end quote, during a search of the Avery property, proposed undisputed fact number 74. In MAM, production notes that were shared with Chrome, Netflix's creative team admitted that it seemed, quote unquote, very thin that the call by Mr. Colborn would be the key to the case. Proposed fact, undisputed fact number 75. In MAM production, Netflix sought family pictures of the Averys to include in the series, saying, "Let's make them look like a very happy family." Proposed undisputed fact number 76. They also identified an image of Avery looking a little smug as one that should be replaced with a different shot while discussing a version of a MAM episode proposed undisputed fact number 77. What's this footnote?
The fact that he's taking all these show notes, them just discussing, how to put things together. It's just ridiculous.
Yeah, they're trying to say that Netflix had control of it, and they didn't. They made suggestions, and that's all.
Exactly.
And this footnote, Netflix said.
Sorry, the fact that it's going on about what Stephen's family says, obviously anybody's family members, their mums, their dads, their grannies, their aunties, their uncles, their cousins, if they feel that their family member has been done wrong by anybody, whether it be police, lawyers, teachers, whatever, they're going to say something and they're going to have their own opinion about it. So for him to be moaning and saying that, oh, because Stephen's dad says that the police fitted us up, then that hurts my feelings, so I should be compensated for that. Oh, you fucking shit.
Again, that goes right back to their decision to not participate. That's their fault. That is
Can I, yeah.
Please.
Do y'all really think Colborn is making these allegations, or do you think a third party has watched the documentary over and over and over again to come up with a argument of potential liability for minute edits and certain things that they don't like the way they're told?
Well, here's the thing.
Because Colborn's only, after filing the lawsuit, Colborn's only watched his testimony an hour and 15 minutes
at most, and that's including
hour 2-season documentary.
And that's including what he was shown during the deposition.
That's right. So I don't see Colborn seeing all of these problems. I just don't. He's not the smartest tool in the shed to begin with.
We kind of talked about this a couple of times, that number one, we don't have any solid information that says the third party was in contact with Colborn prior to him seeking a lawyer beginning in January of 2016. We don't have anything. I can't find anything. I haven't seen anything. That happened a few months later. If you remember, Christina, you've seen it. And we went through the letter yesterday as well that she wrote to Farak, pretty much roasting him over the coals. Of that, he did that article in the Post-Crescent. So anyway, we don't have anything to prove that she was in contact with him prior, basically, to NAM or right after it came out.
Why would she be?
Well,
why would she?
Well, okay,
she had no interest in him until she saw a path to exploit him to make money.
That was to answer your question as to who gaslit him so bad. Was it her?
Yeah.
And we don't know about it? Well, we don't have any proof of that. I think it was Kratz and some of the other officers that saw it.
Mike Griesbach as well. I mean, you see
him too.
The early on
possibly
emails in 2016 where he's like, oh, they're making the Manitowoc Sheriff's Department look bad. He kind of is initiating a lot of that too, in my opinion.
Well, and he did an interview, if you remember, Jinx, second week of January 2016, a few weeks after MAM came out. He did a sit-down interview. We've got it. So it could have been him as well that gaslit him so bad that he's like, you know what? I'm just going to sue your pants off.
I don't even know if they gaslit him so much as they said there's a huge money-making opportunity here. It's not fair that these foreign people, non-Wisconsinites, can come in here and make millions of dollars in our state and we not receive a penny. Maybe. I have a feeling it's more greed than actual loss of reputation.
Oh, there's definite greed going on.
Oh, yeah. And I think it's more, how dare you question what we do? It's very much very ego-driven.
Absolutely.
Even if this third party wasn't involved prior to him saying that he wanted to sue, this was a perfect opportunity for somebody like Mike Griesbach to hook him up with this researcher that did his book.
Yep. That's exactly right. Make a little introduction and we're off to the races. And on top of that, she was also heavily involved in requesting open records request. Heavily.
Yeah.
So.
And those started when? Do we know when she started requesting records in this case?
Well, I don't know about Manitowoc because I don't have access to those. That's what they wanted to charge me $5,000 to get those. So, but from Calumet, it started in fairly early in 2016. I won't say like extremely early, but I'll say probably no later than May or June at the latest of 2016.
I think it was even before that. I think there's a record of her requesting stuff from the courthouse that's actually on the courthouse like stuff, if I remember right.
Oh, you're talking about in the compilation record? Yeah, absolutely. It is there. That's right. Anyway,
Kelly in chat says, does anyone know if those people who gave their bad opinion of law enforcement were ever harassed by law enforcement afterwards? With nothing would surprise me with this police department, Kelly, to be honest. Yes, it's a possibility that they could have been harassed, but we don't know for certain. We don't know. It's just speculation on our part that, yes, these people could have been harassed. And then N4 is I'm assuming Stephen attacked Teresa at 3 p.m. Why would he wait until 6 or 7 p.m. when Brendan came to kill her for 3 hours holding her, and he had to be the coldest minded and bloody guy I have ever seen? Yeah, it just does not make sense. The state's narrative does not make sense. They say he had 5 days to clean up, but they were on the property for the 3rd. So where is the 5 days that he had to clean up? There is just too many questions like that for us to answer them all, and the majority of them we can't answer. We can speculate, but we can't answer
beyond speculation. Beyond speculation, we can't make it work. We just can't. We've tried.
Needed a co-defendant that was going to snitch him out so he could go back to prison. That's why he waited for Brendan. That's complete sarcasm.
Yeah, well, that's my question that I've been asking now openly here. I've been asking it for longer, but openly, if Brendan was so involved in this, why did Kratz wait 5 fucking months to go after him? No one can answer that question. No one. Because the truth is, from what we can see, he had to have Brendan. He had to have Brendan to make that link. Anyway. Okay, let's continue on. And this
by January 31st, 2016, she's adding the Colborn call onto her YouTube. So she must have been doing or working with someone doing FOIAs by January of 2016.
That's very early in the case.
Because the documentary came out December 15th, right? Of 2015. December 18th.
First on one of these cases was January 15th that I see her taking or asking the courts for records for Brendan.
So, photos, wasn't it? Wasn't it photographs, Jinx?
I believe it was photographs. DVD. Brenda took out a DVD of photographs on the 7th of March 2016. So you can kind of see her, they're progressing just like just like the truthers did with the crowdsourcing. They released a couple records at a time, asked for records. So Brent, let's see what she took.
Yeah, I remember looking.
It doesn't say, and then she got photos again in February. This is Super Pickle, I'm pretty sure.
Yeah.
And then Brenda Schuler shortly after her in March. So they were working. The Gilters were working all together too. I believe Brenda is Super Pickle is in Convicting TV. How do you think she got there? She got there because of Brenda, I'm sure.
Absolutely.
I think that they're all part of the original media company hired to combat the negative image and any problems that making a murderer caused. DOJ, the state of Wisconsin, the criminal justice system.
Well, they hired that PR firm. Manitowoc did. Absolutely.
And I think if we had the capability to seek records to confirm this, I think my opinion only, I think we would find that Super Pickle, Brenda Schuler, all of them are subcontractors or actual employees of that PR firm.
Is that
I
PR
think-
firm called Creative Consultants that is run by Laura Wiegert? No.
Yeah, Mark Wiegert's wife. Yeah. It wouldn't
That's it.
surprise me.
That's interesting.
And Jinxie and I were chatting the other day, and we were looking at some publicity shots or some publicly available photos of Brenda Schuler and Andrew Colborn's new girlfriend. And they are, to me, if you look at them, it looks like they were shot by the same photographer.
Maybe they were.
And I
Maybe
find
they.
all of
Maybe,
that
maybe they were.
interesting. Yeah. So was that because she wanted to have a good photo on file for media reports, or for me, in case she's wrote about socially, or is that because her and Brenda Schuler know the same photographer? I mean, this case is just.
And then I have to
brand
ask, is that photographer Trinity Rose now, who was a friend of Teresa Hallback, who is also depicted in Convicting TV?
That's interesting.
See? Yeah. I mean, and that's how it is. The connections in this case, Wisconsin isn't that big, and law enforcement is not that big. And people who are willing to publicly go on the record support, because most people don't want to talk about this case at all, for or against. If pressed, they're going to say he's guilty and then not say another word. But to actually go on the offensive and defend law enforcement to the extreme, like being done here, it's a small crew. And I find that interesting.
A lot of people don't want to get publicly involved, they for work or, whatever reason, even though they may be involved privately in work.
Want to be publicly involved. Didn't she say something about she didn't want this stuff to come public?
Yeah, right. But she wants to get paid for it, though. And I don't blame people for not wanting to go on the record, because they got to live there, and cops have guns, cops have handcuffs, and cops have the keys to the jail cell, and the ability to arrest. That's right. And
the ability to frame.
That's right. Look at how many years Stephen Avery and Brendan Dassey have lost of their life because of Stephen picking the wrong bar to break into all those years ago, picking the wrong one. I mean, it was his cousin before she was a cop's wife. She's the one that started it because she'd get drunk and run her mouth about him. Not that what he did was right. I'm not defending his actions at all. But he was ignorant. He didn't think about her being a cop's wife. He thought about her being his drunk cousin that was spreading rumors about him.
Right. And would shut her damn mouth.
And he wanted to scare her. But that shows you how low his IQ is, because he didn't go past her being his cousin to her being a cop's wife and him already in hot water with Manitowoc County.
Yeah, I mean, he should have went to damn, the husband's name, I can't remember his name now. Mine went blank. You should have went to him and said, Morris. Yeah. You should have went to him and said, look, you need to talk to Sandra and tell her to shut her damn mouth and quit spreading this crap about me, or there's going to be problems. Please talk to her. But he didn't do that. He blew up.
Bill, I think. Isn't it Bill Morris?
William.
Yeah.
Anyway.
Well, see, because she was family, I mean, I think you're right, Christina. He wasn't thinking at the time at all about her being a cop's wife. He was thinking about her being a member of his own family, going about spreading shit all over the community about him that wasn't true. And the way we would have sorted that out in Glasgow was that she would have got took in the back and she would have had a few slaps. You know what I mean?
Right.
Yeah.
And family, you know.
I feel
take
like
a slap, you know, and that's it. That's the end of it. But because she was married to a copper, it escalated for there, and she thought she was above the rest of them because she was married to a copper. And I mean, that's my opinion. That's how I feel about it.
I'm with you on that. And I also feel
Wait.
like
Here's another thing for you guys to think about. She is the wife of a cop who went to the police and basically accused Avery of flashing himself to her out on the road.
Yep.
Don't they already have suspicions of Gregory Allen being a flasher, a
That's right.
Tom, and yet they never investigated Gregory Allen for those claims either.
No, but they took that so serious that they went out a morning to with her and to ride out in the car. They kind of hid in the car.
Rode with her.
Rode with her.
Let me set the scene for what she's alleging. This is October, November, 4 or 5 o'clock in the morning, because she worked early morning shift. 4 or 5 o'clock in the morning on a deserted county road in 1984 in rural Manitowoc County with no street lights. She's saying that she would go to drive by. She lived about a quarter mile from him. She's saying that he would wait and somehow know when she was leaving her house, and he would run out naked to the road and
with his Johnson ready to go.
Yes, and finish right when she was passing by. And no one ever witnessed it prior to her allegations. And cops actually hid in the car and they drove by with her, and it never happened.
Never happened.
And convicting is actually, those who support convicting in Stephen Avery's guilt actually believe that story.
This allegation. Unproven, totally unproven. Just say the words. Total crap. Yeah.
And that was Gregory Allen's thing. Like, he would walk up to people at a bus stop. Like maybe she's mistaken on where she would see it, because sorry, but she was also a known alcoholic or drunk in the area, that she was seeing it the night before and drinking about it and waking up and it was just on her mind. And who knows if Gregory was out on the street at any time on any of these blocks willing to flash himself. Maybe not masturbate, but at least flash himself to somebody maybe driving by. Who knows?
Well, here's what I think. This is how I think she got the story. I think Bill, who was a jailer, so he was doing the bookends, and he was doing, they cops talk. I think Bill was coming home from work and saying, man, there's this dude running around Manitowoc, peeping Tom. He's stealing bathing suits off clotheslines. He's breaking into women's houses with his shirt over his head. He's masturbating in front of them. And I think she was mad at Steven because he had broke into what's-her-face's husband's daddy's hunting trailer up in Crivets. And she's like, you know what? I'll start problems for him. And I think her drunk, addled brain morphed Gregory Allen's crimes into what she considered a believable story about Stephen Avery being mad. Yeah, that's my thinking on it.
It's plausible. Anyway, let's move on. I'm going to read this footnote. Netflix has stipulated, though, that counsel documents within this Bates range are authentic. Okay, good for you. Okay, anyway, in contrast, defendants worked to replace another image of Mr. Colborn in an early version of the MAM trailer with what they call, quote-unquote, squirmy shot instead. Proposed undisputed fact number 78. Summary judgment standard. A motion for partial summary judgment may be granted if there is no genuine dispute as to any material fact and the court is satisfied that the movement is entitled to a judgment as a matter of law as to the issues identified in the motion. Argument. Plaintiff seeks partial summary judgment on the issue of publication, which is believed to be undisputed, and as to three discrete issues relating to certain republished statements by third parties that appear in Making a Murderer series, MAM. Number one, The defamatory meaning of the statements as they appear in MAM. 2, an actual malice as to the statements. And 3, the statement's falsity. The issues raised by this partial summary judgment motion do not extend to other issues that the plaintiff believes are appropriate for consideration at trial based on all of the facts. These include, among other things, the false and defamatory nature of the statements in MAM and of the statements that are contained in MAM when considered as a whole. The defendant's actual malice in publishing the other statements and MAM as a whole. Any issues relating to the various defenses anticipated to be raised by defendants with respect to MAM as a whole or as to any part of it, including their assertions of a fair report privilege or their claims of substantial truth. Another footnote here. Footnote 2, although plaintiff contends that comparison of the MAM broadcast to Avery trial transcripts demonstrate, standing alone, that MAM is not a fair report of the Avery trial, it is plaintiff's position that the consideration of the video, imagery, graphics, and music should be considered as evaluating any quote-unquote fair report defense. Susan, you want to read for a little bit?
Sure. Can you scroll up? Let's see. Number 1, defendants published MAM. There is no dispute that Netflix published MAM and that the Chrome defendants intended that Netflix do so. Proposed undisputed fact. Well, that's undisputed.
Yep.
Therefore, plaintiff is entitled to partial summary judgment on the element of publication of the statements in MAM. 2. Actual malice can be found as a matter of law as to republished third-party statements. Republication of third-party statements subjects a publisher to liability as if he had made the statements himself. This case is explaining that under Wisconsin precedent, defendant could not defend statements as, quote, true because he indeed had heard such rumors, end quote, because that is not a defense to a defamation action. Rather, the defendant was required to prove the truth of, quote, the defamatory charges repeated by the defendant, end quote. Bullshit. Let's see. Secondary publication by a newspaper, magazine, or periodical may expose such a publisher to liability. Moreover, in a defamation case in which actual malice must be shown, actual malice can be shown by a defendant's reliance on 1, sources that are unverified or anonymous, 2, sources that are inherently improbable, or where there are obvious reasons to doubt the veracity of the source. As shown in the table below, MAM contains numerous statements that repeat or embellish third parties' accusations against Mr. Colborn and the law enforcement conspiracy in which they claim he participated. Apart from the MAM embellishments that are identified, all of these statements are made by 1, Mr. Avery, who has been convicted of murder, 2, Mr. Avery's family and friends, 3, Mr. Avery's advocates and agents, including out-of-court statements by attorneys and his investigator, and 4, unnamed and therefore essentially anonymous bar patrons about whom defendants have acknowledged they knew nothing regarding their possible personal biases. See chart below. Posed undisputed facts.
Yeah, I don't know.
Read that?
Yeah, unless there's interest. I mean, we can read some of these. Some of them we've already kind of went through, but you can read a few of these. You know, the episode timestamp broadcast, and then the statement and/or MAM embellishments.
Episode 1. Stephen Avery voiceover. They had the evidence back then that I didn't do it, but nobody said anything. Episode 1. Kim Ducat, Avery relative, states on camera, they weren't just going to let Stevie out. They weren't going to hand that man $36 million. They weren't going to be made a laughingstock, that's for sure. They just weren't going to do all that. And something in my gut said they're not done with him. Something's going to happen. They're not handing that kind of money over to Stephen Avery.
Yeah, I don't think that's an embellishment. I think that's her opinion. I mean, that's not
exactly.
That's not an embellishment.
Photos of plaintiff and others are shown during Kim Ducat's statement.
So it's a voiceover. Well, big fucking deal.
Right. 2. Steve Glenn, identified as Avery's counsel in the civil case against Manitowoc County, states, quote, the day of or on the day after Stephen's release, law enforcement officers in Manitowoc are writing memos to describe activity that had occurred almost 10 years earlier. They don't do that unless they feel threatened, end quote. So, Episode 2, Steve Glenn states, quote, we learned during litigation something that we had absolutely no knowledge of before the lawsuit got started. That 1995 was a very, very significant point in this thing.
Of course it was. It was a very important thing. Again, that's an opinion. It's not an embellishment. The judge has to look at this and say, what the fuck?
Are you serious? Yeah. Episode 2, video deposition of Colborn is shown in the background with Steve Glenn voiceover. Image of Mr. Colborn.
Probably talking about the phone call.
Probably.
I think what was just up above, he was talking about.
Yeah,
Steve
writing memos. Mm-hmm.
Yeah. Steve Glenn continues.
But guys, how many documentaries have we all seen that they do voiceovers? Somebody's talking and they show other things in the either video or photos.
Well, they got to show something, right?
The documentary.
It's a voiceover.
That's right. A documentary is not a verbatim account of what happened.
Absolutely not.
A documentary is an account from a person's perspective of an event in time or something. Now, I just want to add the judge's words and ruling on this motion is going to say a lot about what kind of judge he is.
I think it's going to be granted the summary judgment. That's my opinion, but I could be wrong. He's got to see that.
Anywhere, if it was anywhere but Wisconsin, I'd be right there with you.
Yeah, but Ludwig so far has seemed to be an extremely fair jurist. I've not seen anything that tells me he's not. He questions both sides when questions need to be asked. That June 14th hearing where Griesbach and Barker absolutely flamblasted, he was mad as hell, rightfully so too. But he held it together. He held it together. I just can't imagine. I bet he had words for him afterwards, though. I can't imagine he didn't. Susan, read this next one here about Stephen Glenn.
Okay, from episode 2.
Yep.
Steve Glenn continues, quote, and that there is not only something to this idea that law enforcement had information about somebody else, but there is serious meat on those bones. I mean, serious meat. What we learn is that while Stephen Avery is sitting in prison now for a decade, a telephone call comes in to the Manitowoc County Sheriff's Department. Image of Mr. Colburn's report is shown in background. From another law enforcement agency, saying that they had someone in custody who said that he had committed an assault in Manitowoc and an assault for which somebody was currently in prison, end quote.
Again, I can't see this as an embellishment at all. I just don't. None of these so far. Nothing.
No. Did
they misrepresent what Glenn said, or did Glenn say those words?
He said those words.
Okay,
Yeah.
and he is an attorney, right? He is allowed, I think he has the qualifications to say this is extremely suspicious.
Yeah.
And it shows culpability.
And 95 was a big event. It absolutely was.
Yeah.
There's no doubt about
Yeah.
it.
And you know what would be interesting? We need to see if Manitowoc reported, or if we need to see what coverage Gregory Allen's assault got in the media when he was arrested, when the DNA match came back, and when he was did he take that to trial, or did he take a plea on that Green Bay case? Does anybody know off the top of their head?
The 96 case where he got caught, I don't remember.
I think he got 60 years.
60 years. I don't recall. I really don't remember.
No idea.
If Henberry's still here, we need to look into that. Because that's going to say a lot about whether that would, okay, because we need to also remember on the timeline where this civil suit case was, when Teresa Halbach disappeared, and when Stephen Avery was arrested. Those things are not mentioned here because, of course, that doesn't help the plaintiff. But there's a reason why all of these people had the opinions they had. And
Sure.
I find it very interesting that the plaintiff isn't even acquiescing to that, right? They're trying to pretend it didn't happen.
Susan, read number 3 there where it says unidentified female bar patron.
Continues. Quote, I don't care what anybody says. That's a lot of money to pay out from here in Manitowoc County. It's a small area, and I really, truly believe the county didn't have the funds to pay it out. And they can say, oh, you really believe the Manitowoc County Police Department and the FBI and everybody came in and they set all this up just to have Stephen Avery guilty of this thing? Yes, I do.
Again, it's an opinion.
It's an opinion.
What else we got here?
And, to me, I mean, I think it's important to show this stuff in this case. The locals' reactions and yeah, their opinions.
Let's not forget about Bobby Salas's letter written in 2008.
That's right.
His opinion about all of this. And what was the guy's name where they had the fake blood?
Oh, good God.
Hudson.
Hudson.
Yeah.
Kenneth Hudson.
Okay. That case clearly shows cops will do what is necessary to convict the person that they want.
Mm-hmm.
Yep. They put a target on that kid and got him. Here's another one. Read number 3 where it says Dean Strang.
Dean Strang, speaking out of court, is shown stating, quote, I didn't see them plant evidence with my own 2 eyes. I didn't see it. But I do understand how human beings might be tempted to plant evidence under the circumstances in which the Manitowoc County Sheriff's Department found itself. I don't have any difficulty understanding those human emotions at all, end quote.
Exactly. And read Buting.
Attorney Buting, speaking out of court, states, in quote, so you've got motivation for the officers to want to get him. And then when, lo and behold, there's this woman who disappears, and one of the last people she saw was Stephen Avery. Now we've got him. Aha, we knew it. They conclude that he's guilty right off the bat. And they thought, we're going to make sure he's convicted. And they helped it along by planting his blood in the RAV4 and by planting that key in his bedroom.
Which goes directly to their defense.
Ah.
And let's not forget that Jerome Buting had experience with that other case.
Armstrong.
That framed. Yep.
Yeah, actually, he was wrapping that case up when this case came about. Okay. Well, I think that's,
That's a good example of what he's complaining about. And it's basically any time that the light is shown on their, bullshit of their investigation, that he's pissed off that anybody could have the gall to accuse law enforcement and clean Colby.
exactly. You can't say anything. If you say anything against them, then, well, no, we can't allow that. That you're going to get sued for defamation. But to have an opinion or have a statement because of other issues that say, look, well, that's weird. That looks really strange.
Stating facts, basically.
Absolutely. Anyway, this is we're page 13 of 17. So we can go ahead and read the rest of it.
Okay, as to the republished statement, actual malice can be found as a matter of law under the standard articulated in Saint Amant because of the evident inherent biases of the sources. But in addition, communications between Netflix creative team representatives and the filmmakers established that they intentionally stacked these third-party statements to tell a specific story emphasizing the law enforcement conspiracy in which Mr. Colborn is identified as participating. For example, Netflix series advised Chrome to use Ms. Ducat's statement that the county was, quote unquote, not done with Mr. Avery to impart, quote, a more explicit ending to an early episode that makes it clear that in the next episode, the cops are going to seek revenge, end quote. Proposed undisputed fact number 71. Netflix representatives also endorsed using Avery's father's statement, quote, they framed an innocent man just like they did 20 years ago, end quote, as a cliffhanger.
So
Proposed
what?
undisputed fact. Defendants cannot credibly contend that they did not specifically select the third-party statements to advance a preconceived law enforcement conspiracy narrative in MAM. In their communications, the defendants referred to those associated with Manitowoc County law enforcement as, quote, the baddies, for whom a specific bad guy theme music was to play during their appearance as part of an overall thriller atmospheric score. Proposed undisputed fact 73. Defendants' own documents also show that they were actively looking for opportunities to use source material in such a way to, quote, allude to the fact that cops may have planted something, end quote. Proposed undisputed fact number 74. There is no reasonable inference but that Netflix knew that defendants were using third parties' words to convey the accusations of a law enforcement conspiracy, and in fact urged Chrome and its representatives to enhance them. And despite the prominence given to Steve Glenn's tale of the alleged genesis of the conspiracy in the supposed quote-unquote cover-up of the call that Colborn received while working at the Manitowoc County Jail, in comments shared between defendants, Netflix admitted that it seemed very thin that the call by Mr. Colborn would be key to the case. Another proposed.
Kelly McGallion, she says none of those statements refer to Colborn specifically. That's a good point too, because he's got to say that they were defaming him, right? Like his reputation. And in all actuality, when Pa Avery said that, he was talking about Manitowoc County Sheriff in a whole.
Exactly. Yep. He makes it all about himself. Who does that? A narcissist?
Someone feeling guilty that he had something to do with it.
Yeah, possibly. In contrast to the knowingly damning portrayals of law enforcement, Netflix advised Chrome to ensure that Stephen Avery and his family were portrayed in a positive light, regardless of whether the portrayals were accurate or not. For example, Netflix sought family pictures of the Averys to include in the series, saying, quote, "Let's make them look like a very happy family," end quote. They also
pictures of Teresa Hallbach's family looking like a happy family too. I mean,
right?
Is he saying that because there's pictures of them having happy times, that means that maybe Teresa's family is also fiction and they weren't as happy as they seemed?
Right. And we also have to remember that these are notes. These are suggestions.
That's right.
Anyway, yeah. They also identified an image of Avery, quote, looking a little smug, end quote, as one that should be replaced with a different shot. In contrast,
what shot should they have shown instead of him looking smug? What?
Yeah. Somebody, you know, in the editors or whoever they are, just propose that.
Yes, in Wisconsin's going to put on this side dish of ma'am to show the other side, right? Because then they can put their own pictures in.
Right? They can include that one looking a little smug.
That's right.
In contrast, defendants worked to replace another image of Mr. Colborn in an early version of Ma'am trailer with a squirmy shot instead.
Wait. I want to know if he's going to sue Convicting TV when it comes out, because I remember when they released the pictures of him wiping his tears, and we all had our opinions about that too.
It should be noted that the communications described above do not by any means constitute the totality of evidence of actual malice that plaintiff intends to present at trial with respect to Ma'am as a whole. At trial, or in response to any motion for summary judgment the defendants may file, plaintiff intends to demonstrate that Ma'am as a whole contains numerous other defamatory statements, graphics, and video, including edited video of the plaintiff's own testimony that changes his answers to court testimony. The examples cited above are provided in this context to refute any suggestion that there can be any reasonable inference that the third-party statements that are the subject of this motion were not intended to convince viewers of the existence of a law enforcement conspiracy to frame Avery. Number 3, the third-party statements are defamatory. As shown in the table above, the third-party statements, whether taken individually or in combination with each other, and when paired with Ma'am's images, video, and graphics, accuse Mr. Colborn and or a group of Manitowoc County law enforcement, that includes Mr. Colborn, of planting evidence as part of a conspiracy to frame Stephen Avery for Teresa Hallbach's murder. There can be no reasonable argument that these are not accusations of criminal conduct. Nope, there can't. Accusations of criminal conduct are defamatory. Therefore, the statements in Ma'am that repeat third parties' accusations of criminal conduct by Mr. Colborn are defamatory as a matter of law. Comes straight from the trial, Colborn.
Yep.
Number 4, Ma'am is false as to accusations that Mr. Colborn participated in a conspiracy to plant evidence and or planted evidence. The statements by third parties that are republished in Ma'am and that accuse Mr. Colborn of planting evidence are false. Mr. Colborn testified at the Avery trial that he did not plant evidence to attempt to frame Mr. Avery. That's an undisputed fact. And of course, you know, he's under oath, for God's sake.
We saw that with our own eyes through Ma'am, that he testified.
We sure did.
That's right.
Right.
Defendants can identify no facts that suggest otherwise, nor any reasonable inference that can be drawn to support any such contention.
You can read that footnote if you want.
Footnote 3, a statement is defamatory as to an individual if his identity is ascertainable. A statement is also defamatory as to an individual if it is made to a recipient who incorrectly but reasonably understands it to refer to the individual. They didn't make up this stuff. They didn't write a script.
No.
They showed us what happened as it
Right.
happened and gave us the opportunity to see that what the prosecution was putting on. There was a key, there was a bullet, there was some burn bones, there was this. They showed all of that in MAM. They showed them testifying. Then they also showed the other side of like the Janine chick with the EDTA and other people. They didn't have as many experts, but they did do their due diligence, I think, in showing both sides. It was up to the public to decide on an opinion of what really happened in this case.
Right.
That's right.
And Andrew Colborn is a public official who ran for public office, and it is not against the law to not believe what you're told officially.
That's
and
right.
It's not the law to say that you don't.
Well, and again, these people had the opportunity to give their opinion, just the same as a lot of like the female bar patron that's unidentified and others that made statements. You know, there was one guy that made a statement. Well, I didn't really believe he did it until, Brendan Dassey, and then now I've changed my mind. They showed that. I think maybe that might be in MAM too, but nonetheless.
They showed that in MAM 1 too, because that was part of how it went. Like
that's right.
Go back and look at the web sleuths from back when it was coming out. Started in November of 2005, the thread for there. And you can see how these locals and these people are like, oh, well, I think they framed them, da 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 da. Then the Brendan Dassey press conference was released, and you see a very change in the public's opinion when
immediate.
They see that.
Yep,
as
immediate.
We see that also in Making a Murder. We see that they went out and did a press conference and basically said, look, Brendan did it with Stephen. And
right?
We had the right to decide for ourselves whether or not we believed those statements they were making.
That's right.
It's like we are committing a crime because we don't believe what they're saying.
That's right.
Really?
It's you're defaming them.
Defaming them. Yeah.
Crap. Go ahead.
And there's no anti-slap laws in Wisconsin. Like they can sue frivolously just to get somebody to stop talking about them in the public. Like basically, they can do that.
Yeah.
They can try at least. There's no like law saying you can't bring these frivolous lawsuits to our courts.
Crockett has a good point. Who was it that said I could tell Stephen was guilty by the look in his eyes?
Oh, that was
Bray.
Yep.
Who was it?
Bray. He was over that YES organization that did the first posters.
No. I don't think it was that guy. It was another guy that worked for the county.
I thought it was Jim Bray.
I don't think that's the same guy though. I think the other guy is something else. I don't know if that's the same guy.
Oh, okay. Well, nonetheless, it was, yeah. You could tell by the way Avery's eyes looked that he was guilty. Oh, sure, okay. Anyway, go ahead.
This next paragraph is ridiculous. To overcome a summary judgment motion as to this element, defendants must come forward with specific facts sufficient to raise a genuine issue of material fact that plaintiff in fact planted evidence or participated in a conspiracy to do so.
Fucking
bullshit. Yeah. Oh my God. They have to prove it. In other words, any inferences that they seek to have drawn in their favor must be reasonable inferences. Jesus. To the extent that defendants may attempt to rely on suspicions that they contend were outlined in MAM, all of those alleged suspicions were based on nothing more than pure speculation and conjecture. For example, MAM's insinuation that Mr. Colborn could have planted Miss Halbach's vehicle key in Stephen Avery's bedroom is based on nothing more than the fact that Mr. Colborn was in the room when James Link discovered it, and that he was accused by Avery's defense counsel of having a bias or grudge against Mr. Avery after having been deposed in Avery's civil suit. I never thought Andy was the one to plant the key.
Nope.
There are no facts from which reasonable inferences could be drawn to permit a jury to conclude that Mr. Colborn, in fact, planted any evidence to frame Stephen Avery, nor that he conspired to do so. Accordingly, plaintiff should be granted summary judgment on this issue. Good luck. Conclusion. For the reasons set forth above, plaintiff respectfully requests that the court grant his motion for summary judgment and rule that it is determined for purposes of these proceedings that 1. Defendants published MAM, and 2. Defendants published the third-party statements described in proposed undisputed fact number 2 with actual malice, and 3. The statements are defamatory. Not going to happen, Colborn.
No.
And you know how he only wants partial summary judgment? Because he wants a fucking jury to award him $20 million.
Yeah. Good luck with that, too.
Yeah.
Yeah, this is a recent document, too. This is the 16th of September, so this was a little over.
He's going to get a fair jury after everybody in the world's watched MAM?
Right. Except for people in Manitowoc and Colborn.
I have to apologize. I skipped over something that I shouldn't have skipped over, and those are exhibits for one of the. Yeah, well, we're not far back, so let me correct that right.
And by the way, Jim Bray is a politician in the Manitowoc County area, and Jay Bayer is the one who was the head of the Yes program.
Yeah, thank you very much for. Yeah, I got the names confused.
And was it Jim Bray that said that?
It was. He says that he could tell Stephen Avery was guilty by his eyes. So you wouldn't want him on any case investigating anything, because he will totally be tunnel visioned to you only and only you, because he can tell you're guilty just by looking at you.
Yep. God, that's a gift, isn't it? Jeez.
Yeah. Ultra Collector said Nancy Grace said something along the same lines about looking at him and she can see that he's guilty.
Yeah,
Nancy Grace
not surprised.
is another moron who shouldn't even be on TV.
We call her Nasty Disgrace.
Yeah.
Yep, that is
she
nasty.
She gave the foreword for Ken Kratz's book, didn't she? So, I mean, that says something too right there. She's all on. She was corrupted herself. Got to stick with her own.
Yep, her own ilk.
All right, so we got to step back in just a couple of documents, and I apologize. I totally forgot, so you'll just have to try to forgive me if you can. So we're going back to document 283, and there are 32.
Like the one.
Yeah, we read it.
To restrict the.
Yeah, we read this. So these are there's 32 exhibits attached to her document. Okay, so we're gonna go through them, and I apologize.
Those are the ones she was asking to have private, right?
Well,
they're actually published.
Well, there's some things that are published.
Huh. Okay.
There's like 2 records in there that you can actually read if I'm looking at the right ones. I looked earlier and you can't read half of the ones in there. I don't remember. I've looked at too many. I just don't remember what all's restricted or what else. And there's not a damn thing in it. But we should show it anyway. We should show, what we're doing, and boom, done.
It won't. I mean, if they're restricted, it won't take us but a minute to go through them, and we'll just move on. But this first one looks like it's from Kevin Vick. There's his law firm out of California. To the Honorable Brett Ludwig regarding restricted exhibits to the Declaration of More Demos in support of motion summary judgment of defendants, Chrome Media LLC, FKA, Synthesis Films LLC, Laura Carty, and More Demos, Colborn v. Neck. Honorable Brett H. Ludwig, defendants, Chrome Media, gives the names there. Producer defendants respectfully submit this letter in support of the motion to restrict document number 281 and restricted exhibits to the Declaration of More Demos in support of producer defendants' motion for summary judgment, docket number 282. The restricted exhibits 1 through 32 are video files on USB drive. The USB drive will be delivered in a sealed envelope via Federal Express on Monday, September 19th, 2022. And I'm pretty sure that's one of the documents I showed a clip of. They're sealed, and they don't want it in the cloud.
Those are like the 20-second videos that Moira and Laura made. Yeah.
And I'm betting that pretty much all these are going to say the same. Restrict. So on us. And I pulled up through Exhibit 7. So I don't want to crash. I don't want to crash my reader, but just a second.
Yeah, I think they're probably all restricted. All 32.
I'll go in and pull up. Let's just go from 29 to 33.
Case 10 says, I can tell Colborn is guilty by his eyes.
See, all these are.
The tears in his eyes, or what?
By the popping of his knuckles, the sweat on his forehead.
Yeah, see, all those except for the first one are restricted. And yeah, so give me just a second. I just wanted to show that so everybody would see. I didn't skip anything. And while you were reading there, I thought, are there exhibits to one of these? I think there is. And I found. And again, I apologize for that. Give me just one moment.
We should do a series called What Ken Kratz Left Out of the Trial.
Yeah, really.
I watched a little video earlier with him and Dean. Somebody put somewhere on Discord not long after Mem came out, and Colborn saying, you know, that the how ridiculous it was for them to show the blood vial with the hole in it because, you know, that was put in there by the nurse. Well, what's to say they couldn't put another needle in that same hole or just take the top off and pour blood? I mean,
that's right.
You know, it's such a stupid argument.
Yep, going through the same hole that was already. Absolutely.
All his arguments. And having to carry sweat around. I mean, just take his shoe and rub it on there. For fuck's sake.
Came up with the vial of sweat in the first place. That was also
Really?
Ken Kratz.
That's
Yes,
right.
it was.
It was Ken. Yeah. All right. So we're back current. So we just read document 280. And this is the declaration of, let me double check. I don't think we have any more. Attachments until 283. Document 286 has attachments with it, so we'll get to those too. I just wanted to double check as we go. Anyway, this is the declaration of April Rockstead Barker. It's 4 pages. I'll give Susan. Alice, are you still here? You want to read a little bit?
Yeah, I could read a little bit. Aye, no bother. Okay, declaration of April Rockstead Barker. April Rockstead Barker declare under penalty of perjury as follows. 1. I am one of the attorneys for the plaintiff in the above matter. This declaration is submitted in support of plaintiff's motion for partial summary judgment. 2. Attached as Exhibit 1 hereto are true and correct copies of pages from the transcript of the deposition of Moira Demos, taken in the above matter as provided to plaintiff's counsel by the court reporter, with some added identification and marker as to pertinent portions thereof. 3. Attached as Exhibit 2 hereto is a true and correct copy of a printout from the Wisconsin Circuit Court Access Program page for State of Wisconsin versus Stephen Avery. Number 4. Attachment as Exhibit 3 hereto are true and correct copies of pages from the transcripts of the deposition of Lisa Nishimura, taken in the above matter as provided to plaintiff's counsel by the court reporter, with some added identification and marker as to pertinent portions thereof. Number 5. Attached as Exhibit 4 hereto are true and correct copies of pages from the transcripts of the deposition of Adam Del Deo, taken in the above matter as provided to plaintiff's counsel by the court reporter, with some added identification and marker as to pertinent portions thereof. Number 6. As Exhibit 5 hereto are true and correct copies of pages from the transcript of the deposition of Moira Demos, taken in the above matter as provided to plaintiff's counsel by the court reporter, with some added identifications and marker as to pertinent portions thereof. Number 7. Attached as Exhibit 6 hereto are true and correct copies of pages from the transcript of the deposition of Adam Del Deo, taken in the above matter as provided to plaintiff's counsel by the court reporter, with some added identification and marker as to pertinent portions thereof. Number 8. Attached as Exhibit 7 hereto are true and correct copies of pages from transcripts of the Avery criminal trial, Manitowoc County, for February 20th, 2007, as printed from a publicly available source online. Number 9. Attached as Exhibit 8 hereto are true and correct copies of pages from the transcript of the deposition of Lisa Nishimura, taken in the above matter as provided to the plaintiff's counsel by the court reporter, with some added identifications and marker as to pertinent portions thereof. Number 10. Attached as Exhibit 9 hereto are true and correct copies of portions of Exhibit 7 as marked at the deposition of Lisa Nishimura, taken in the above matter, except that the email addresses have been redacted and exhibit page numbers have been added due to the length of the exhibit and because Bates numbers are not sequential within the document. Number 11. Attached as Exhibit 10 hereto are true and correct copies of pages from the transcript of the deposition of Adam Del Deo, taken in the above matter as provided to the Plaintiff's Counsel by the court reporter, with some added identification and marker as to pertinent portions thereof. Number 12. Attached as Exhibit 11 hereto are true and correct copies of portions of Exhibit 5 as marked at the deposition of Lisa Nishimura and referred during the deposition of Adam Del Deo, taken in the above matter, except the email addresses have been redacted. 13. Attached as Exhibit 12 hereto are true and correct copies of an email message and a portion of a document containing production notes produced in discovery by Netflix Inc. in this matter, except that email addresses have been redacted. 14. Attached as Exhibit 13 hereto are true and correct copies of pages from the transcript of the deposition of Moira Demos, taken in the above matter as provided the Plaintiff's Counsel by the court reporter, with some added identification and marker as pertinent portions thereof. 15. Attached as Exhibit 14 hereto are true and correct copies of portions of an email thread that was produced in discovery by Chrome Media LLC in this matter as, and then a number, except the email addresses and personal contact information have been redacted. Dated this 16th day of September 2022.
Okay, so attached to this, give me just a moment. Attached to this particular document, there are a number of exhibits as Sheila outlined. I'm going to pull those up. I'm going to pull part of them up anyway. We'll see what they. But this is 286. All right. That's going to pop in here. This is 286, document 1. And it looks like these are, again, going to be excerpts. I don't remember reviewing it. This is a 3-page document. I don't see anything specifically added by a highlighter, like she said, by Mark. So I propose that Susan, you want to be a lawyer, or you want to be the person answering questions?
I'm sitting here talking and unmuted. I see the marker to the left. See where they like line 13.
Oh, they
14,
lined
15.
it. Yeah, I see that.
Yeah, so that's what they're submitting, I think.
Yeah. So what do we do that part? I'll ask a question, and you can answer.
Okay.
All right. Starting at line 13, was your understanding that if Netflix signed on to the project, that it would be one of the first docuseries to be broadcast on Netflix?
Yes. At that point, there weren't any. In fact, there wasn't an original doc division yet. So yeah, we were meeting at a pretty early stage in the development of that company.
Okay. And then the next page, question. And then ultimately, we'll get into that, but there was a contract entered into between Netflix and Synthesis, correct?
That's correct.
It looks like it's July 2014, and she says, yeah.
Mm-hmm.
And then this next page, question. Oh, thank you. To your knowledge and understanding, Netflix did approve the final treatments of all the episodes of Making a Murderer, Season 1 and 2, correct?
That's correct. I don't recall a formal approval. I just know that they aired them on their service.
Okay. That's the end of document. Oh, I gotta turn this just a second.
What a weird way to submit those.
Yeah.
Someone else thinks that, because this seems quite lazy and robot.
Yeah.
Remember what I told you about the compilation of record? There it is right there. You can see, this is the compilation of Stephen Avery's record. You can see it there on, it's page 2. You can see part of it. You can't see it all because it's multiple pages for Stephen, multiple pages for Brendan too. But it lists everything as the record goes by. You know, it's a.
And wait a minute, I had to step away for a minute. So why did they submit this?
I think that this is.
It's probably in black marker what they want down below. What they want.
Yeah.
Red.
Well, this is it. This is it. That's all there is.
Oh, huh.
But is this again?
I think that. I don't remember what they said number 2 was. I think I closed to
the fact that he was found guilty. I don't know.
That he wasn't found guilty of rape and other things too is on there as well.
Yes, it is. Or the charges that were dismissed.
That's right.
Isn't Andy going around telling everybody he's a rapist and was charged with rape and convicted of rape? Because that's actually not true.
No.
And that's Andy. A defamation of character.
Wouldn't that be a defamation of character if you're telling everybody that Stephen Avery was convicted of mutilating a body and kidnapping and sexual assault and false imprisonment, when he was actually, some of these charges were dismissed and one was found not guilty.
That's right.
By the court, so by the jury. So shouldn't he not be saying those things?
That's right. I guess we're just including it, so it'll be part of the number 3. Yeah, here we go. This is it's only a 1-pager, Susan. So
okay.
you can do
the left half.
Yep, that's right.
Or the right half, I guess. Yeah.
Yeah, it looks like it starts. Looks like it's. Yeah, it looks like it starts on the.
Okay.
Starts on the left, maybe. Let's see. 171. Page 170. Yeah, okay. It goes from on the left. It goes down and then back up.
Okay.
Yeah. So. I'm going to ask this question. I don't have it highlighted, but it says, okay, thank you. And then line 19, and backtracking for a second, there are 2 questions that don't relate that I wanted to ask them. Then I will wrap up with those. Did you review all the final cut of the Making a Murderer Season 1 episodes before they were publicly aired?
I don't have a clear recollection of that, but I imagine that I did.
By Ms. Barker. Okay. They were all approved in any case by Netflix creative prior to being publicly released, correct?
That's correct.
And then back up to top, page 172. So under subhead that says, quote, Season 1 - episode 3, end quote, there's a scene or there's some bracketed text, and there are 3 paragraphs that start with the words, quote unquote, unidentified woman or man / bar patron in colons. Yeah, in colons. If you'll take a moment and review those.
Okay, I read that now.
Thank you.
Do you want me to stop after? Where do you want me to stop?
The bottom of the page is fine.
Okay, I've read it.
And my question is, well, first, does that reviewing that trigger a recall of individuals in the pool hall as featured in Making a Murder?
It's really vague. I have not watched the series in years and years, so I do have a vague recollection of this sequence.
Okay, so my question was simply whether you knew the identities of these individuals.
I do not.
Okay, and similarly, I'm assuming you don't know anything about them personally.
I've never been to Manitowoc, Wisconsin.
Yeah, I understand. I didn't mean that you personally know them. I meant as far as any details about them that may have been provided to you, you either don't know or don't recall. Is that correct?
I don't know.
Then directing your attention forward in the document to the page that has page 55 of 56 in the following at the bottom. Okay, they don't go any further than that.
Yeah.
Okay, that's the end of Exhibit 3.
They don't even have their black fucking lines correct.
No, I don't. It's terrible. And this is a 4-page document. Okay, they played a video. Question by Miss Barker. Miss Demos. Okay, this is Demos's. Do you recognize that excerpt as a portion of Making a Murder, Episode 3 broadcast?
Yes.
And who was the woman speaking?
I don't recall her name. She was a local resident who we had met that day.
Were you specifically in the establishment there for the purpose of interviewing people for the purposes of Making a Murder project? Let me look at the page here. Hold on. This does follow the page.
Yes.
I guess we can read this. And about how many people did you interview that day?
Where are we? Oh, I don't recall exactly. I think we went, it was a local bar, and it was a way to try and find local residents who might have been willing to share their views. So a few people were willing to speak on camera.
And when you approached the people, what did you tell them?
I don't exactly recall.
Did you write down their names somewhere at that time?
Yes.
And did you ask them any other questions about their background or history or affiliation?
I don't recall. I imagine we asked if they were, from around there. We wanted to speak to people that lived in the area. I don't think we asked other background questions besides that threshold question.
Okay.
Because what does it matter what somebody does for a living?
No shit. Any kind of background.
Can't they have an opinion even if they're homeless, or whether they're politicians, or, isn't anybody entitled to have a thought or a point of view?
Understand if it had been billed as a pro-police, pro-prosecution documentary, and then once it was released, it was a more unbiased lens of the case, them getting upset with how they're portrayed, right? But yeah. They never said they were going to do anything but report the case, and they're not in any way drawing conclusions. They just simply reported the facts. Now, what were they supposed to only include people's opinions if they were pro-police?
Apparently.
I
Yeah.
think part of showing those opinions too was because prior to March, these opinions were of possibly Manitowoc planting evidence or being corrupted in some way. And after
Right.
the press conference, they did another one where they go and talk to people to see what their opinion is now over what's being told over the media. And their opinions had changed some. So
That's right.
showing you also the story. This is what happened before press conference. They believed that there was possibility of framing. After the press conference, they believed that Brendan was somehow involved, and that was because of the way, Ken
Press.
and all that bullshit.
Including members of his own family. Because isn't Chuck and
Right.
Earl both on there saying they think he's guilty now? And Barb screaming at him, saying,
Yeah.
what have you done to my son? Yeah.
Yeah.
So, I mean, this is like just, if it wasn't true, it would be absurd.
Yeah, it's all fantasy stuff. Go ahead, Alice.
Yeah, but not only that, people in Manitowoc thought the cops were corrupt. Some of them, anyway, thought the cops and that were corrupt way before Making a Murderer came out because of the Ricky Hartsfiddler case.
Maybe before Steve's trial.
Yeah. They covered that up as well because they were saying that it was supposed to have been one of their cops that hit him during the night as he was walking home. You know what I mean? And they covered it up and everything like that. So some people in Manitowoc thought that police station, department, whatever you want to call it, was corrupt anyway, way before Making a Murderer came out. So for him to keep saying about the public thinking that he was corrupt and everything like that, no, your department made your community think that you were corrupt because of something that happened way back in the 90s. You know what I mean? So that impression was already there before Making a Murderer even came out. So when Making a Murderer came out, it just emphasized these people's opinions even more that that department is corrupt as fuck.
Hey, I want to say, you're right. You're right, Alice. I want to say hello to Dr. Silkman, and looks like Dozer's going to have to take off. Hey, thanks for dropping by, Dozer. We appreciate the support. Hope you've enjoyed what we've presented so far. There's a whole lot more that we still haven't got to yet in these new documents. So, I hope Dr. Silkman's doing well today. Thanks for jumping in the chat there. So, anyway.
Hey, Cherie.
Yeah.
Hi, Cherie.
Yeah. All right. So let's continue on. Number 13.
Okay.
Do you know whether that individual that had any prior personal interactions with any of the Avery family members?
Well, I know in the scene she's playing pool with Chuck Avery. I don't know if they met that day at the bar. I know she at least interacted with him there. I don't know about anything prior.
And do you know whether there were any contacts that individual had with law enforcement in Manitowoc County prior to that day?
No, I do not.
Okay, we skip over here. Let me slide this over. Okay, going over to line 20 on the page 152, it looks like. Question, and again, had you asked any background information from this gentleman other than whether he was from the area and willing to comment on the Avery criminal charges?
I don't recall asking other background questions beyond those threshold questions.
And again, do you know whether that individual had any connection to any of the Avery family members?
No, I do not.
Do you know? Do you know whether he has had any prior contact with law enforcement officers in Manitowoc County prior to the date of that interview?
I do not. What the fuck difference does it make?
I don't understand. So what if they're friends of Avery's and they have an opinion about the law enforcement because they're friends?
Right.
Does that I mean, what does that have to do with anything?
Jesus Christ.
Hey,
Oh my God, I'm getting frustrated.
Are they?
Yeah.
Is he thinking in his mind, or the lawyers thinking in his mind, that the judge is going to say, "Hey, you can't be going around questioning law enforcement officers. If they say something, you can't question that." Surely he's not thinking that.
Oh, shit.
Truly grasping at straws.
Yeah,
How you try and build a case when you have nothing to build a case with.
that's right. So it's a house of cards. All right, let's read this next one. This is line 12. Question. Okay, and again, same question. Did you ask any of the background questions regarding of that woman, other than whether she was a local resident or from the area, and whether she was willing to comment on the allegations against Mr. Avery?
I don't recall asking anything beyond that.
And that's the end of document 286-5. It's a 4-page document.
Ooh, that's so damning.
I know, it's terrible.
Christ.
Hey, where do
God, people that knew Avery had an opinion about law enforcement. Well, holy shit, Zeus.
Where do I find the motion that these exhibits are attached to?
It's document 286. And didn't I send you the link to the doc?
I'm looking at them.
That's what I tried to ask the other day. I don't see the actual the document that goes with the exhibit.
Yeah,
we just read it before.
Yeah, it's
doing this, right?
it's in that. It's actually on the foul play in the foul play library as well. If you just go to the foul play library and go to other cases, Colborn's is at the bottom. If you pull that up, it's right there. And actually, Zoe attached, instead of listing them separately, she attached all the attachments to each document itself.
This is the thing for a partial summary judgment, the motion.
See why what this is supposed to be in support of. Like, what is this supposed to prove in Fantasyland?
That he was defamed.
Yeah, that these people went around and had a differing opinion and weren't necessarily supporting, and that ma'am included that, or Netflix included that on purpose to defame him.
Making it sound like Andy was guilty of planting shit.
Correct. Okay. You start on line 2 on this next one.
The pool.
Wait, did any of those people in the pool hall actually say, yes, Colborn, we believe Colborn?
No.
Who planted this, that, and the other things? Okay.
The pool. I think the pool hall patrons, I think we are using that as a synonym.
Okay. Did you know the identities of any of these people at any time?
I don't recall that.
Do you know how these people were solicited for participation?
I do not.
Do you know whether any of those people had any connections to the Averys?
I do not.
Do you know whether any of them had any law enforcement encounters with Manitowoc County?
I do not.
Yeah. That's the end of 280. This is 286 document 6. We'll move on to document 7, and it's sideways. Just this may be trial transcript. It's 11 pages. I'll see if anything's highlighted that they may be trying to capture. Otherwise, we're not reading all it.
Yeah.
This is February 20th, so this was a couple weeks after the trial was going. It looks like it's day 7.
Trial day 7, yeah.
And Colborn testifying. There's nothing highlighted. Not reading it. We've read this before, and I'm not going to read it again.
Yep. Nope.
So yeah, let's move on to document number 8. And again, we have another deposition. Make this a little bit bigger here. Whoever's this is they're starting on page 131. Okay. I was hoping it might be evident to you, so that's fine. We'll just move forward to the pages marked ADX COL 1975 through, well, why don't I just start with that, directing your attention to the document marked NEX COL 1975, which should be the next document in the Exhibit 7.
I have that.
If you could just take a moment and review it, please.
Okay, I'll read it now.
Thank you.
Okay, I've read it.
This is, or the document base stamp.
Fucking quick.
Yeah, I'm a speed reader.
You are fast.
Yeah, I think this is the deposition of Adam Del Dio, whoever that is.
No, it says Miss Demos.
Oh,
Oh, wait. Oh, from you. I think you're right. Yeah.
Yeah.
From you too.
Yeah.
I think you're right.
This is base stamp. This is base stamp 1975. Is an email message from you to Ms. Demos, Laura Riccardi, Mary Manhart, and Lisa Dennis, dated July 11th, 2015. Correct.
Correct.
This in the text message. In the text of the message, it indicates that you are forwarding to the recipients of the series notes for making a murder as of that date. Correct.
Correct.
Okay. So then directing your attention to the next several pages marked 1976 through 2012, if you could just please take a moment and at the last page, that didn't make sense. If you could please take a moment and at least through those. Okay, I see. Through those. Gotcha. All right, let me scroll.
At least page through those, yeah.
Yeah. And then it starts at line 9.
Go back up. Yeah.
Yeah, it'll get there. I don't know why it's lagging.
Yeah. Okay, I've skimmed it.
Okay. Does the document identified as 1976 through 2012 appear to your recollections to be the attachment in your July 11, 2015 email?
It appears to be.
And did you create the attachment to the email message?
I did not. I'm sure I contributed. As I had mentioned before, we worked very collaboratively on the creation of the notes, but this specific type of format was not my format. I guess I didn't really need to read that, but you asked the question.
Yeah.
Why would they want the answer included?
I know, that's weird, isn't it?
Yeah, that looks like all that.
Is Cherie still on here?
No, I think
she is.
I think she took off.
I think the reason she has shrunk this down and submitted several pages on one, don't they have to pay for each page submitted in a civil suit?
I don't think so.
I think so.
Yeah.
I think I remember hearing that or reading.
I don't think they have to pay for it. I think that there's a limitation on how many pages they can submit, so they compressed it.
Okay. I know that there is. I know there's filing fees, and I know that. I'm wondering if it really is. This isn't like a low budget lawsuit.
Well, we're still wondering who the hell paid. We're still wondering who the hell paid.
Yeah. Who is backing this lawsuit? Who is paying for it?
Or give me. Well, we suspected that for sure.
The only person I can think of.
Andy Hale. Why Hale? Why not Sean Reck?
Or Sean Reck, yeah.
Or Sean Reck, yeah. Or.
Andy Hale was in a docuseries I just saw recently.
Yeah.
I think
it's a tag team effort by the two, personally. Yeah.
It's not wrongful convictions, if I remember right.
I'm guessing it was pro law enforcement.
Mm-hmm. Well, you got to remember, he's trying to revamp he's trying to sell the story that after building his career and his fortune defending corrupt cops, he now wants to expose them. Bullshit.
All right, this next one.
Murders at Starved Rock. That's the one he was in recently.
Oh yeah, that's on.
And that's all.
HBO Max.
I don't know if that's pro cop. I think that's kind of. It's kind of against the isn't it the one where the kid his father was the DA, and he's like going against his father basically by showing that this was a wrongful conviction. So
I don't remember it.
Thought he was part of all of that. So he was the lawyer for the guy who was wrongfully convicted, Andy Hale, if I remember right. So
no, he's definitely portraying himself as a wrong writer now after spending his entire career defending.
Well, yeah, I'm just saying he's changed. He seems to have changed his tune because now he's doing this Starved Rock thing
for this case, right? But I wonder how much money is involved, and I wonder why. It would be interesting to see what motivated him to do it for this case, but not any other case, because he defended cops from Chicago during all of those 90s cases that we've done brief little segments on, where, I mean, they've now created a fund to, they've allocated millions of dollars to repay wrongfully convicted prisoners who were held out the window by their pant legs and threatened to be dropped if they didn't confess to a crime. He defended those assholes. So, yeah, I'm not buying the I'm trying to right wrongs done by cops story by him at all. There's something more to it, but that's just me.
What's on the screen now. This is an email chain. It's 72 pages long. We're not going to read it because they're show notes. These are notes that were passed between the creative team and the filmmakers. I mean, I'll link it later if you guys want. Whoever wants to go read it, more than welcome. But it's just pointless. These are suggestions. We covered this yesterday. Again, I hope that Judge Ludwig just looks at this and says, "What are you doing?" It goes on and on. I'm not going to cover all this. I was just scrolling down to see if there might have been something different, but there's not. These are all show notes. So let's move on to document. That's document 9. And document 10, we have more deposition. And we'll maybe find out who this is. Let me scroll that
now, are they highlighting some on 86 and some on 88, or is that both those lines for 88?
I think it's, well, it looks 88. Like the only thing, yeah, it's just that one section. Well, it goes into 89 as well. Okay. Directing your attention to then to NEXCOL, I'll just say the number, 132. The next page after that series in Exhibit 5.
Walker says, do you mean 1932? Parker says, I'm sorry, yes. Oh,
yeah, that's right. Yeah. Directing your attention to 1932 in Exhibit 5. Do you see that?
I do.
And that is a copy of an email message from Marianne Javadi to Lisa Dennis dated November 20th, 2014, correct?
That looks correct.
You were copied on that email message, correct?
That looks correct.
And the message states that the feedback on the first 4 episodes are attached, correct?
That looks correct.
Directing your attention to 1933 through 1941, you can take a moment and look through those.
Okay.
So the documents at 1933 through 1941 are the Making a Murderer notes for episodes 1 through 4 and referenced in the preceding email message, correct?
That looks correct.
Well, I'm not sure why they wanted that shit highlighted. I didn't really reveal a damn thing. And it's a one-page document, so moving
Weird.
on. Looks like this is an email chain. It's 10 pages. And again, this looks like creative notes. Let's take a look. It is. We're not reading.
Nah.
We've already looked at a document similar to this yesterday.
Good God, they're asking the court to read a lot of shit, aren't they?
Well, yeah, I mean it's overburdensome in my opinion.
Okay.
It's just a pile-on of just garbage. Document 12. This is sideways. Straighten that up. I'm going to guess this is more notes because it looks like it's attachments. Making a Murderer, episodes 5, version 2 notes. This is a 3-page. Back sideways again.
Show notes. Discussion.
Yeah, it's nothing. And then attachment. Look, I think this is no, we got 2 more. Okay, we got more deposition. And this is very short. Question, then directing your attention or strike that. Mr. Videographer, could you please hand to the witness the exhibit marked 52?
Yes, okay, I have that. What the fuck?
I have no idea.
Bonnie,
I have no idea what they're doing here. Attention. Okay, what page is this other one? Okay, this is the next. Yeah, it's 218 to 219, so it's following.
Okay.
I will direct your attention to a document that is, I'll count the pages from the back, approximately 8 pages from the back, or the last page of the document, base stamps 481 in the lower right-hand corner.
Okay, I'm on that document.
On the approximately in the lower third of the page, is there a copy of an email message that was sent by you as part of an email thread with individuals involved in the production of the trailer for Making a Murderer?
Yeah, I can see that on December 6th. I'm writing an email. I can't quite tell who it's to, given this, but yes, it's about the trailer.
And that email message continues on into page 482 of that document. Is that correct?
Yes.
And boom, that exhibit's done. I have.
is the point in that? Really?
No idea.
Oh my God, man.
Has Barker filed a document tying all this into a reason why the summary judgment shouldn't be granted? Or
no, I don't think they've replied. I don't recall, but I don't think they have.
Okay. All right.
I could be wrong. Don't hold me to that, Christina. There's several more documents in front of us, but I don't think she has.
I think that's what this is. This is supposed to be proof that Netflix played a creative role, that they helped in defaming poor Andrew, and that Andrew's case isn't garbage, but it is.
But it is, yep. And this looks like an email
about editing and stuff.
It is, because you can see the timestamps. And it's from more. And I send to that document. And let me double check. I'm pretty sure document 14. Give me just one. Yep. 286 had 14 attachments. and that's the end of them. I've lost brain cells, and I didn't have that many. I really don't have any to lose. I lost brain cells going through those 14. I literally did. It's terrible. Absolutely terrible. I feel bad. I kind of feel bad for April Barker. She is so outclassed with Lita, and that's my opinion. Hopefully, I don't get sued for defamation over that.
And she's a Harvard Law School grad, and so is Vic. Vic is an honors Stanford undergrad, Harvard Law School grad.
What?
And Barker is a Harvard Law School grad. But you cannot tell it from this case. Well,
Vic, he's made some weird ones, but I got to tell you, from what I've seen, he's better than she is. He's actually done some pretty decent documents.
Yeah, I attached a copy of his little bio on their website, on his law firm's website. He's a reputable attorney for sure. You can't be successful in the LA entertainment industry faking it. He's been on I forget the exact wording, but the best lawyer list since 2015. So, best entertainment lawyer or something like that, some kind of LA thing they have. And he's a partner at his law firm.
Right. So, right.
But just some of these things that they're including, I'm wondering if they're not trying to get them included so Cam can't mimic them without getting sued for copying Making a Murderer. Because it's clear that, in my opinion, let me qualify that, BS from Wisconsin has no clue how to put together a documentary because she has no film school, no history of working in film prior to this. And these notes that are included in Barker's filing will allow her a template to try and create a better than generic documentary.
Well, she better not edit it at all, because in that regard, she'd be wrong, right? You're not allowed to edit anything.
I think convicting is a done deal at this point. They're just trying to get it aired.
It's going to be interesting to see how. It's going to be interesting. We're all going to watch it, right? Whether we puke while doing so, break our TVs, we're all going to watch it.
I hope if it's a paid program on his streaming site, somebody pays for the episode and we all watch it together, because I don't believe we should be paying him for this.
No, one flat fee. We all binge watch together. I agree. Let's have a Cam watch party with you. Speaking of which, that other show, we need to schedule a time for me to air it too. The one we discussed.
I'll bring the liquor. I have lots of liquor.
Hey, I made wine and liquor. All we need is constant cheese.
Yeah.
All right. I think it. Hold on a second here.
Can someone bring the fudge from Uranus?
Well, Becca can bring that. We're gonna stop. This is where we're gonna pick up again next time. Which
good.
I'm starving. I'm starving, Susan. I don't know about you, but I'm.
Jack.
We're gonna start here. Yeah, you rushed home and read your ass off.
What time is it for Alice?
You have kept me up near enough every night this week till at least bloody 3 in the morning. So
we took 2 nights off, so that was, if you stayed up late on those nights, I really didn't do that. But let's go ahead and end it. This is document 287. This one doesn't have attachments. I've already looked. Document 288 has a couple. Let me see here.
Undisputed facts. It seems like we've already read all those.
Probably.
Yeah.
Yeah, so we go back into another chart. So this is going to be a scan and move on. So, yeah, we'll start here. Like I said, probably Tuesday. We got Jeff Jones will be on tomorrow night with the premiere of Discussing a Murder, so I won't interrupt that. So we'll go Tuesday. Hopefully, I'm not saying we can finish Tuesday. Probably not. It's probably going to take 2 more episodes to finish through all these without, being on for 12 freaking hours.
Did y'all go over? So it looks like, what's a partial summary judgment versus a full summary judgment? Do we know that?
Just parts of their
They're wanting
motion they want summary judgment on.
Yeah, they're wanting to cherry pick out of it.
So is she acquiescing that a lot of his case needs to be dropped because they don't have the evidence?
No, she made that clear. They're not acquiescing to that at all.
Okay, and so another question. So if that's the whatever the title of it was, there's obviously a motion somewhere where she's making the argument that they have a case. We just haven't found it yet, right?
Well, it's either that way. If we haven't found it or they've not submitted it, one of the two.
Yeah. All right. I'm curious to see how she argues this. I'm not going to lie.
All righty. With that said, let's go ahead and wrap up. We'll start again, like I said, probably Tuesday afternoon or here in the U.S., evening for Alice and the Europeans, and early for the Australians. It'll be Wednesday for the Australians, actually. So, they're in the future. I always try to get, I like Doc and Kel and Cap to send us some lottery numbers, but they never do. Don't understand that.
I don't either.
Yeah. So anyway, with that said, many thanks to Susan and Alice and Christina, everyone that's here, everyone that's joined in the live chat. We really appreciate it. Continued interest in this case. Jinxie, absolutely. Everyone that's participated, really appreciate it. These cases are really interesting, and we'll see where they go. I know we've got some more interesting reading coming up in these. So if you like what we do, give us a like and a subscribe. Turn the bell on. And we'll be back Tuesday afternoon. With that said, this has been a Foul Play production.